Can you guys hear me?
Yes, hi, Anita.
Hi.
This is Frederica Siegel. I'm Chair of the CB2 Land Use Committee. I'm joined by Anita Brandt, who is Chair of the Soho NoHo Working Group. We are waiting for a quorum of the two committees, and then we'll begin. I see that Chris Marte is on an attendee. Perhaps we want to elevate him. I see that Deborah Glick is here. Thank you very much for that. I'd like to know Deborah's time frame. Ideally, I would just like to introduce what we're talking about, but if she's on a tight schedule, please let us know. Thank you. One, two, three, four. Give it a couple more minutes. All we need is one or two more people, I think. All right, I think we're good to go. Janine, did you want to say something to begin?
Welcome, everyone. I'm Janine Kiley, the chair of CB2. This meeting is focused really on two issues: penalties and associated with some legislation, and pathways to legalization. So we're really focused on JLQWA, co-ops and condo units in our community, which impacts more than 3,000 residents, which is why we're sort of having a special meeting on this topic. But thank you everyone for joining. I'm going to turn it over to Frederica.
Thank you.
Back to Frederica.
Thank you. There we go. So our agenda tonight is, Eugene, can we go first to the protocol slides? There we go. While everybody is reading that and the next one, we need to take attendance, and Anita and I will do that. So here we go. Asking land use committee members to please sign in. Eugene, I see you. Michael Levine?
Yes, I'm here. Hello.
Great, thank you. John Paul, I saw you. Susan Wittenberg?
Hi.
Susan Wittenberg?
Yes, I'm here.
Thank you. David Gruber? I saw Donna, I saw Katie, I saw Sean,
Yes,
and
present.
I saw Anita. Anita, do you want to do attendance on the working group?
The only two additional people who are not on the land use is Anthony Wong, who I see is here, and Akila, who I don't see.
Okay,
And she-
fine. Let me know if she,
She didn't respond to my,
Yeah,
Yeah.
I talked to her earlier and she plans on joining, so I'm sure she's just running a bit behind.
oh,
all
good.
right. Eugene, can you advance to the
I have the
following?
slides, Frederica. It's to me. Back to the
Okay,
agenda.
Okay, great.
Which
Um,
slide do you want?
That's the one. Let everybody read that. Other members of CB2 who are not on the committees are certainly welcome. And yes, let's promote them. And at some point I need to keep track of that, but I'll do that later. All right, so we can go back to that slide about the agenda. Thank you. So the agenda tonight is to discuss Intro 2443, that's Councilmember Chin's proposed legislation to increase DOB fines. Really, in the absence of more information, our chief goal here is to identify the things that we don't know and the things that we would like them both to consider and to answer. And just for a little bit of background, on November 9th, the subcommittee, the City Council Subcommittee on Zoning and Franchises, held a hearing about local law to amend the administrative code of the City of New York in relation to increasing penalties related specifically to joint live work, Artists for Artists. They linked this bill to the Soho NoHo working plan, and if it's passed, it will become effective immediately. As Janine alluded to, according to the data gathered by the city planning, there are over 1,636 units designated as joint live work, vis-a-vis the certificate of occupancy. That is a significant percentage of the 8,000 people who live in Soho NoHo, and I heard Janine say it's almost 40%. The current legislation, which is general and does not identify joint live work, it's just a civil penalties legislation, says that current amounts of penalties would be capped at, would be $1,250 with a cap of $25,000. Councilmember Chin's bill would significantly increase the current penalties and act as a deterrent for these, in her opinion, these units to be occupied by non-artists. A first violation would be subject to a penalty of not less than $15,000, with subsequent violations up to $25,000. In addition, monthly penalties of $1,000 for each month would be imposed. And I just want to bring to your attention the fact that it says a penalty of not less than $15,000. That does bring up the topic of how high could it go and what's the basis for making that determination. The sections of the administrative code that would be affected are major violations of the zoning resolution, not specifying joint live work, as I said. And the second part of it is, hold on one sec, please. One section is immediately hazardous violations, and the other section addresses general civil penalties. So that's outlining the background here. And if we could go back to the slide with the speakers. And I see we have a good crowd here. Could we do that? Are we doing that or?
We are doing it, but once I stop sharing,
Okay.
I have to read out.
I want to
just a
thank
moment.
Deborah Glick for joining us. I want to thank Anthony Drummond and Kana Irvin from Councilmember Chin's office. Iraq Chahansky from Rivera's, Councilmember Rivera's office. And we have a couple of people from the City Council Land Use Division. Chelsea Kelly, Angelina Martinez Rubio. Is Raju Man with us? I guess not, but those, Hannah Irvin and Anthony Drummond will be presenting. So if we could, Anthony or Kana, who would like to go first?
I think Kana's
Connor.
presenting.
Hello.
Connor. Okay.
Hi.
Thank
So
you.
I'm actually with Iraq right now. We're in the legislative office, so we don't have video capacity. Sorry. Just to everyone who I have not met before, my name is Connor Irvin. I am Councilmember Chin's deputy chief, and I'm also the legislative director. And I worked on this bill with our amazing land use staff who have been very helpful and helping us try to get just update a lot of these old zoning laws. I think that you all know there is no perfect solution here. And because the city has taken a long time to try to work out some of these kinks, I think the longer we've waited, the more difficult and just difficult the process has been. So the bill, the intention of our bill right now is, and first of all, yes, it is just an increased fine. It's just an increase in the penalties. And I want to add a note there that with the data we have from DOB, we know that in the last decade, there have only been 12 violations issued to people for violating this, the joint live work quarters for artists. So even though that we are proposing currently an increased fine, I would say that it's very unlikely that many more people are going to be affected by a higher fine. That being said, we are looking to incentivize some sort of remediation, whether that be a conversion legally through DOB or assisting people with being certified. So they are legally there. They are conforming with the requirements now. And I also want to note, I know that there has been some frustration or just confusion with how do I get certified or how do I start the process with DOB to legally live here if I'm not an artist. And that is something that our office, as well as Councilmember Rivera and the Land Use Division, we are working very hard to make these processes as easy as possible, or at least just make them more streamlined. So we are working very hard on that. Please rest assured. And as soon as we get more information, especially from DOB, we will be following up. I want to also just let everyone know we had a really successful meeting with DCLA, and we got some great information about how to become certified. I know that we've been getting some emails. I'm sure that the Soho NoHo stakeholders that are here too have been asking, or at least been getting the same emails from other folks in Soho NoHo asking about how to become a certified artist. And I was pleasantly surprised to hear that it's actually a bit easier than I initially thought. And we will send out an email with the link if people are interested in that. And I will put my information in the chat so people can get that. Also, just about the JLWQA bill, it is an introduction, and with every other bill that we introduce, as stated, it is open to amendments. And that is why I am here. That's why Iraq is here, as well as Anthony and other people from our team, so that we can hear what everyone has to say. I can't be here for the entire meeting. I'll be here for an hour. And I will put my information in the chat. But we do look forward to making amendments because we know that it's not a cut and dry scenario for everyone. There are maybe people who are living in these units and maybe like their parent was an artist and certified at one point, and they're stuck in a limbo of will I face this fine if DOB comes and inspects? And we want to make sure that people who want to follow the rules and they're not, I guess, just flipping their unit for a really high cost to a non-artist, and I guess doing that like a legal conversion, that they're given a pathway to do so in an expedient manner. So that's just a little bit about what I have to say now, but I'm looking forward to hearing what everyone else has to share and their thoughts and feelings.
Thank you. Anthony, did you want to add anything?
You muted out, Anthony.
Sorry, I just got thought I unmuted. No, kind of just outlined it. Only thing I will say is that really, because I know we have a lot of comments we're expecting to hear a lot of feedback. So I'll just leave it at that and listen to everybody and listen to their comments and take questions from there. But thank you guys very much.
Okay. So in the absence of more details, are you prepared to give us any more details about how you imagine this happening, or what the pathway would be for someone legalizing instead of moving out, if they're not an artist living in joint live work? Connor? Anthony?
Sorry, I was on mute. Can you repeat that?
Yeah. Can you give us any more details about how people, well, what I understood you to say was you want to incentivize people to legalize, but you don't imagine enforcement of the current rules?
Oh, so the enforcement of the rules that are on the books now, so that, are you saying that enforcement meaning everyone who is not currently an artist who is residing in these artists or JLWQA units?
That is the subject of the bill.
Yes, I know.
So
But what is your
I
question
heard you to
exactly?
say that you want to incentivize people to legalize, but you're not going to do it in tandem with enforcing the penalty. Did I get that wrong?
Well, if we did see enforcement, then there would be a lot more violations. But that is something that we know DOB has not enforced. And I think that it would not make as much sense to just get DOB. I mean, I'm assuming also the people in these lofts who want some sort of mechanism to avoid high fines and comply in a way that works for them and for the city, they wouldn't want immediate enforcement, because that would mean they would see many, many fines.
Well, but
Also, I
that's
just
what
have to
the law
say,
says.
from
If it's passed, it will be effective immediately.
that's currently what the legislation is drafted now, but I think that we are definitely open to having some, either a delayed period. Many bills are not enacted immediately, but they have for example, like 180 days after the passage, that's when it will go into an effect.
Okay.
So
All right,
that's
thank
something
you for
that
that
we're definitely open to.
All right. I want to be respectful of Deborah's time. Deborah, do you want to speak now or do you want to wait? If that's the extent of the of Councilmember Chin's presentation, would you like to speak now? Deborah? All right, if Deborah's not on, can we?
Well, I needed to be elevated. It took a moment.
Oh, sorry about that. I'm not, I don't,
All of these new words.
sorry.
Yeah,
And can we see Deborah,
yeah.
whoever?
Everybody selects their own,
Yes.
we can see
Okay.
her.
Yeah, we see.
Okay, great.
So I think everybody could read what the legislation was. I think we were hoping to hear a little bit more clarity about it's rather putting the horse before the cart. There's no pathway for people who are living in units there, have a non-conforming use in large part because the definition is very narrow and out of date. And one would have hoped that we would have had clarity about a pathway or recommendations for changes to the definition for certified artist. I know that during the hearings, DCP referred to certified artist, and when somebody said, well, it's not, lots of people have not gotten certified and the arts have sort of changed or broadened, and not everybody fits into what was the 1970s definition or 1980s, they said, well, that's state law. So we are definitely going to look at that. But we're not in session yet. We will be in session in January, although a lot of the early focus in session is around the budget. But we got no recommendations from DCP or any of the council about, or the city agencies about what kind of changes they would be comfortable with. So they reference state law, and while we intend to make adjustments, we'll have meetings with people in advance of writing the legislation so that we don't undermine existing certified artists, but we want to be sure that those who could be certified if the definition was more updated could in fact go through a process. But we also need to have the commitment from the city, which has been, I think, moribund for a number of years, if not decades, in this arena. So we would want to change the definition, be certain that there was a process that cultural affairs would be willing to engage in, and that the information would be available to anybody living in a non-conforming situation, but could be certified if there were a broader definition. But this bill, I'm happy to hear that. Well, yes, it's possible that it would not be effective immediately. And here we are at the 11th hour of both the city and the council, and no action had been taken over the last 8 years in this arena. So it seems a little bit cart before the horse to have the penalties imposed before a pathway has been clarified. So
Thanks, Deborah. And I just want to answer something really quickly. So I'm seeing some things in the chat that pertain to what you just said, especially amendments to this bill. And that's why I'm here. I'm here because it's still a work in progress, and I'm open to hearing everyone's feedback. I'm looking at Michelle's response. Who will receive the violations and pay the penalty fees, the owner or the occupant or tenant? This is something that we're looking into this, and I agree that the owner should be paying the fee. I think that's the same of a lot of laws. I think that there's definitely the precedent that if there's a violating, like a 311 call for a rodent complaint, that's always something that the owner will pay. So I definitely see an amendment that very clearly spells this out, that this is an owner paid fee, not the tenant. And to Ronnie Wolf's point, like I just said, we know that there are some cases that there's a lot of gray area. And I am looking into some sort of like succession right based question that will make sure that we're covering folks who have had like maybe their family member or a spouse had an artist certification, and the person who's still occupying the unit is not certified as an artist, but maybe there's a history of someone in their family who has, like, that's something that we want to hammer out all the kinks here. So we're taking all these considerations seriously, and these two things specifically are what Anthony and I and the Land Use Division are working very hard on.
Well, that's certainly good to hear. It was one of the questions we had, but my concern is if it is an owner who gets a $15,000 fine, that is essentially putting a target on the back of the tenant. And perhaps would be grounds for an eviction. So I think that has to definitely be clear that that's why the pathway is crucial, because you don't want to, I would hope that the plan isn't to incentivize displacement. So, and I have to believe that's not the case.
And this is one tiny part of a very large problem. I agree that this should have been remediated a long time ago, and we're like 40 years too late on a lot of these issues, but this is where we are now. And the fact of the matter is that a lot of these units are not being used as they're intended. And so we have to find a way to move forward, find a rule that will dictate what happens to these units moving forward, and how a lot of these tenants can either be protected, or there can be some sort of sunset period to maybe making sure that they're conforming. This is all in flux, and like, I totally hear your concern, Deborah. So thank you so much for that. Yeah.
Connor, can you
thank
just
you.
clarify here? I mean, I'm at a total loss of connecting what you're talking about with reality at this moment. And I just bring this up is that the underlying zoning was changed in 1971 to allow people who lived in units to live there, but the emphasis on live work was to protect manufacturing. Manufacturing's long gone. And the law has always looked at inviting in residents to allow them to have legal status, and the city just hasn't addressed this for 50 years. And we're now at a point where we're addressing this, but it seems that this is going retroactive to punish people, as opposed when for now with the rezoning, residential is going to be as of right, and you're looking to go back and punish people who are the ones that pioneered the neighborhood, that have made the majority of residents are non-conforming. That's been the case since 1987 when DCP did a survey. This is nothing new. Why are you going back to penalize people?
Sure, Carter, you're right. This is nothing new. And this law has been on the books for a long time. We're actually just increasing the fine. And increasing the fine, I don't think that that's equating that there's going to be more enforcement. I'm not the one who controls enforcement. That's something that DOB does. And if I were in charge of DOB, probably there would have been more enforcement to begin with. So can you clarify any other question there?
Sure.
Excuse me, Carter, can I just interject here? We certainly want to hear from the committee members, but at the time when we open it to the committee members, I know that Chris Marte is here. Deborah has finished her questioning. I'd like to hear from him, and then let's have a conversation among the, as I said, among the committee members. However, Hannah, when you say that the law has been on the books forever, the law never mentions joint live work. It's a general fine structure for certain types of general violations, and suddenly it's becoming simply about joint live work. In a way, it's consistent with the whole Soho NoHo neighborhood plan, in the sense that it seeks to solve the problems not by offering mechanisms, but just by dipping into residents' pockets. So, we understand that part of it. But is Chris here? Does he want to speak? I see you, Chris.
Yeah, thank you, Federica. And you made a really good point. Thank you, Deborah, for hitting on a lot of the good points earlier. I think a lot of us came on here to learn more about this piece of legislation. And I feel like we know less right now of why that it's actually introduced. And so the only question that I have is, what's the timeline? Are you looking to pass this within this year, or is it going to be kicked into the next administration?
Thanks, Chris. I'm not really sure what the timeline is now, because if we make amendments, that will prolong the timeline. And we certainly are looking to make amendments based on the feedback that we're getting here, which is really great, and just some prior conversations with the agencies that have given us some good feedback too.
Okay, thank you.
Okay. Can we move to the next slide and hear from Anita from Soho?
Yes, hi there.
She's chair of Soho Working Group, but she's also
An
a working architect.
Yes, I am. This is about the, can you hear me all right?
Yeah,
We can hear you. We're just waiting for, unless I'm not looking at the right screen.
no,
not
just a
seeing the slide.
moment. Sorry.
Well, I'll start talking while you look for it. What I looked into is, in this long process, which began 2 years ago with our Envision report, or the summary of all our meetings, was that the next steps were to develop pathways to legalize non-artist residents in NoHo. We then wrote our July 2020 CB2 resolution. On pages 4 and 5. We raised many questions and concerns regarding the conversion and legalization, and we received no response. For those of you who don't know, a change of use, which is part of what would legalize it to a residential, is a very involved and expensive process, and just doing it floor by floor is neither practical nor might not even be possible. So I just think that as part of a penalty, we should also have a solution and a way of planning for how to legalize the occupancy. I know it's to keep the, if you're not an artist, then it would revert to a residential, I believe. These are also 150-year-old buildings. They can have no violations, they would need many variances. So again, very costly, very lengthy. In September, at September's CPC review, Commissioners Levin and Ortiz commented that they required and requested additional information on this issue. And really, the only thing I have seen come back to us are proposals for penalties and for an art fund tax. So really nothing practical. I'm sure we'll hear many, many more concerns and questions tonight, but this is a very complicated merging of both a city and a state laws, such as multiple dwelling laws, and makes it very involved. And I think, talking about a penalty, I know it's up in front of us, but we really have no way of visualizing and planning for this big change ahead. That's it for me.
Okay, thank you, Anita. Can I point to, certainly we want to hear from everybody, but it's a lot to ask to be running the meeting, listening, and also recording everyone's questions. It's a very rich chat. And in it, we put the email address of CB2. I'm just scrolling up. info@cb2manhattan. Janine, what's the rest of it? .nyc.gov.
Yes.
Okay, so in addition to what you're putting in the chat and what you're going to say, it would be really terrific if everybody could just take one moment and send their question to info@cb2manhattan.nyc.gov. And with that, I think we can now open it up to committee members. So I see a couple of questions from attendees, but I want to ask first if there's any comments. I hope they'll be in the form of questions because that is, as we said, the purpose of the meeting. So Carter, I kind of cut you off and let you
Yeah,
conclude.
I'm really confused because the majority of rental units are legalized through loft law, and the loft law, the end result of loft law means the majority of the loft law units are not restricted to artists only because they're under once they exit the IMD process, they're covered under the state loft law, which supersedes JLWQA requirements, as the loft law units are directed under another part of the law. So we're really only talking about co-ops and condos. And so the owners that are getting the fines are the co-ops or the condo unit owners. And I'm just very confused because the language is sort of a little wider. And these units, the majority from almost all the way back in the beginning, are the people who raised families here. Many were artists that didn't pursue certification because the units already had received their C of O. The city's definition of artist was called antiquated 1987, let alone now. So there's so many issues. So I'm not sure why we're not focused on solving the problems and why we're focusing on the punitive aspect of this, which is further evolving the neighborhood. And I still don't understand how this law factors into evolving the neighborhood forward to a residential community, which is the whole point of what this zoning is allowing for the first time ever.
Anna, did you have a response to that?
Yeah, so I'm just going to echo what I've been told by council land use, but I'm not an expert on this. I just know that the loft laws are very, very separate from what the bill is covering. And I will workshop the fine details on that, and I can get back to you via email, Carter. If you
Well,
could
that was my point, because you were referencing rental units. Not us. So rental units aren't co-ops and condos.
Can you be more clear? I'm sorry, I'm kind of confused your point.
Meaning people don't use co-ops and condos as rental units that frequently. It's a very small subset.
Yeah, when I was talking about renters, are you referring to when I was talking about like making sure that people who are renting are not getting the fines placed on them?
Well, I don't know. I mean, that's what I'm asking.
Yeah, so, okay, great, thank you. So through my conversations with some folks who live in Soho NoHo, we've had really productive Zooms with some people who are going to be impacted in general by JLWQAs, whether or not they're conforming or not. And they did make this very clear that if a fine were to be implemented, or an increased fine, because this is just increasing it, not implementing it, they would want to make sure that it's not going to the renters. It's if there is someone non-conforming and you're renting from an owner who's not conforming, the fine is going to the owner, not the renter. So that's my clarification there. Because we do know that there are some folks in this situation, I don't know how many, but some people have brought this up, and that's what I'm referencing.
Okay, thank you. Chris, did you want to speak? You had a
Yeah,
question?
yeah. Since this doesn't really create a pathway in any sense, right? Like as many people said, this penalizes folks who currently live in Soho NoHo. Are there any adjacent or legislation that's going to be combined to this to actually create a true pathway for people to be legalized? Or is this a standalone legislation, part of the rezoning, that this legislation might not even pass within this session?
So any introduction is not guaranteed to pass, and this introduction is specifically limited to increasing fines to JLWQA non-conforming units. Any sort of, streamlining process for how to become certified, or if you are not conforming and you want to maybe avoid fines with DOB, that's something that we are trying to work out outside of legislation. And I don't think that that's not feasible to do within this bill. It wouldn't really make sense to amend this to include such a broader range of scope. In fact, I think that would probably be an entire new bill, but that's something that a bill drafter would have ultimate discretion on. Like I said, we had a great meeting with DCLA, and they really clarified some of our points that we just passed on from residents. I think it was a BRC email that alerted us to a lot of these questions, and they were able to answer them very well. Like I said, if anyone is,
Connor? Could you share what you learned from DCLA? They're good answers.
yeah, I'll just I'll find the link and I'll put it in the chat. It's basically a detailed instruction of how to become a certified artist. It's a shorter process than I thought it was going to be, and you know, working in government for 4 years, sometimes, you know, we just wish agencies could move faster. And on this case, I thought it was going to take like a month. They said that the longest it would take for an artist to be certified, which is at no cost to the applicant, is like the longest case, 3 weeks from start to finish. And I think that's very feasible.
Yeah, and so
that's where we can help folks who are trying to like follow the rules, like I said. And if anyone is trying in good faith to work with agencies and they're having problems, like we want to know about that. And please alert us so that we can directly forward those to our contacts at the agencies and say, like, we want this to move forward, and is there anything we can do on our end to help? Also, I just wanted to make a note that during our meeting with DCLA, among other things, we learned that there were only about 4 to 5 certifications processed in an entire year. And those are only 4 to 5 certifications that were even like requested. Only 4 to 5 people even applied to be a certified artist in the last year. So I, again, really strongly recommend that people go through the process. It doesn't seem like it doesn't cost any money from my understanding of it. And from what I was told directly from the DCLA commissioner, it's, I think, like a very fair process. What I will say is that we learned that the artist definition is actually defined by the state. So maybe Deborah, you could help with that, because we actually are preempted by the state in that way, which is really unfortunate because it does seem like the artist definition is very narrow. So.
yeah, and then I guess like my confusion is like, why even create this legislation to increase the fine if it's not going to be enforced? So, you know, I think it's probably a waste of time and a legislation that's just being rushed through to distract from what's actually happening with the zoning.
Thank you, Chris. Deborah, do you think you might be able to put that on your list? Helping if the artist definition is determined by the state?
Well, I think I addressed that earlier, that it was completely out of date, totally narrow, didn't reflect what is current, and that it would have been more appropriate for DCP, the cultural affairs, or the city, anytime in the last 8 years or 20 to have made that request. But because it's been clear that in this rezoning, DCP kept referring to protections really only for certified artists, we went and looked at it and said, well, this is why nobody applies, because nobody can actually, or very few people could meet the definition, because it just doesn't meet the way people are doing their art these days. So it's reflective of where we were when the loft law was first created. And frankly, I find it disingenuous on the part of the city or DCP to be raising it as, well, that's state law. They've never talked to us about, this is a problem. And we'd like to see this updated and give us some input into that. I mean, I don't like to just do things out of whole cloth without conversations, but that seems to be the way people are operating now. So I intend to work with certified artists, those who would like to be certified, but can't fit into the box, the narrow box. And we will work on that, but we are not in session until January. So to put this bill into place before that is frankly inappropriate and possibly damaging to some people who are longtime residents. I'm kind of, yeah, I hear you. Yes, I could help with that if anybody had given me any warning that this was, you know, what was coming down the pike. So yeah, we're going to work on it and try to prevent damage that could be inflicted upon some people by virtue of there not having been an update in a very long time. So yeah, there's no enforcement and no applications because it doesn't work for most people. So yeah, we'll work on it as a way to protect people. But I think the city should have had an obligation to be more focused on creating the pathway, which community board, others have requested for some period of time and have gotten, you know, radio silence since that request went in. So yes, be assured that we will work on that aspect of it.
Thank you.
Now that it's been clear that DCP is looking to save their selves by just referencing something that that they haven't raised before with us.
Agreed. And no one was saying that it should have been dealt with by the state and wasn't. We're just saying now that we're.
Oh, I
focused on it-
understand. I understand
Yes.
that
Okay,
that's
good.
not, CB2 is not saying that, but I got the sense that someone was suggesting that, you know, I should pitch in, which I'm happy to do. But if anybody had had that, who was planning on increasing fines so dramatically, it should have been a discussion we would have had before people were feeling so threatened.
Agreed. Thank you. Question from Michael Levine.
Yes, thank you, Frederica, and thank you everyone for speaking. I want to follow up on something that Anita said before regarding the flip tax for conversion to standard residential use. It seems as though what's happening here is the occupants of joint living work quarters for artists have only two choices, either to pay very stiff fines based upon the Department of Buildings fine schedule, or to pay not just enormous costs to convert their buildings to meet the state multiple dwelling law into residential units if they seek straight residential occupancy, but they're also required to pay an expensive flip tax, which is part of the SOHO NOHO rezoning. So it seems to me as though those who occupy those units right now have who don't meet the standard artist certification criteria have either heavy fines imposed by Department of Buildings or a very expensive flip tax that would be imposed to convert to standard residential use, which would then go into an arts fund. I'm wondering if there's a way, and I'm opening this to our assembly member, to our council staff who's here today, is there a way to reduce the penalties both for, number one, the fine we're talking about today, which is very steep, or in fact, the cost of the flip tax to convert to standard residential use? Is there something else that can be looked at by the representatives of state and city government with us today? I'm going to pose that to the city council members first.
Right. Do we have, did I understand that Chelsea Kelly and Angelina Martinez Rubio were here from the City Council Land Use Division? Is either of you here? and wants-
I don't
know-
see them on.
Okay,
If they
thank you.
join, we'll let you know. They
Okay.
had registered.
Okay, and while you're at it, is Lizette DeParo on from,
No, Andrew
President's
Chang
office?
is on from the Borough President's office.
all right, because please feel free to raise your hand if you'd like to speak.
Lizette is here. I'll promote her to
Oh,
the
whoops, sorry.
panelist.
I missed that.
Mhm.
I just found her.
Oh, there you are under L.
All right, so we're happy to hear from, we're aching for information.
Mhm.
And if someone has information to give, please raise your hand and we'll elevate you. In the meantime, I see Susan Wittenberg has a question.
I was wondering, in terms of thinking of the people who would be impacted by this, there's a large, I don't know the numbers, I don't know what percentage of the 3,000 it is, but we have a lot of people who live in rent regulated units. The same proportion of them could be non-artists as in the other kind of units. So now you have people who have a New York State lease. And so now are these people, now the state and the city are going to go back on the terms of these leases for these people and say, you now owe money because you're not a certified artist when they were given this lease by the state? I mean, it just opens up another area that seems as if no thought has been given to.
Kana or Anthony?
Sorry, thank you. Susan, are you asking if the bill is going to be retroactive? And can you clarify that just so I can answer it?
No, I'm not asking if it's going to be retroactive. I'm saying that has it been taken into consideration that of the 3,000 people or 1,636 units, what percentage of these are people who have New York State rent regulated leases, which mean which are non-artists, which means they were given a lease by the state, and now is the state and therefore the city going to go back to them and question their right to be there and charge them the same punitive fine because they're not artists when they've already been given a lease by the state? Has this been addressed?
That's a great point, and that's something that I personally have not had a conversation with someone in that situation about, but I'm happy to work with our state colleagues and with DHCR to kind of talk about that. We've been having great meetings with people who do fall into like gray areas in a lot of these laws.
This is not what I would call a gray area.
Okay, great. So anyway, I'm happy to talk about this further, and I'm happy to, like, if you wanted to have a phone call, or if you know someone who's in this situation, I think that's actually even more valuable. So
for me to say to you, I know someone in the situation. I think it's a pretty significant percentage of people who rent in the district.
Okay.
But we certainly can discuss it more.
The law is not changing, but we do not control what the city does around zoning and what the implications might be, but we will do everything, people who are, as DCP kept saying, rent regulated units will not be affected. I'm not sure that that's 100% true based on some of the changes that they are looking to. I mean, there are ways in which people who are in rent regulated housing, usually via demolition, can lose their housing. And the zoning changes make that provide an incentive for that demolition. But as far as, and they don't have a lease with the state, their lease with their landlord is protected by state law. So there is not going to be a change or an undermining. If anything, we've strengthened the law. And today, my bill to ensure that tenants in loft buildings have the same access to the housing court as any other rent regulated tenant due to some rather poor decision in Brooklyn. We've remedied that, and the governor signed the bill today. So I'm happy that the state will take actions to ensure rent regulated tenants and rent regulated loft tenants are protected. But there may be ramifications of changes in city zoning that could have a negative impact. And that's why I have opposed the zoning plan in its current form. The incentives lean towards either demolition of smaller underbuilt buildings or to the creation of large retail or office buildings without a lot of affordable housing. whole other issue. But when it comes to the bottom line protection, loft tenants are protected by state law, but not necessarily protected by all of the ramifications of city actions. We can only do what we can do.
Thank you. Coral, you've had your hand up.
Yes, I appreciate that. I have 3 questions. But I'm going to start with the sort of more granular one, which is we did go through the certification process. Our loft originally was commercial when we bought it. And we would have definitely loved to have gone to just residential, but it wasn't an option. We had to go and become an artist certificate. And thankfully, my husband was an artist that became certified. It was not an easy, quick process. I think somebody in the chat has referenced having already applied and not even gotten any sort of response. And it may be because there's not very many people staffed in that agency that currently works on that. I'm not sure, perhaps you know, kind of, but you know, if you've gone from having like less than 15 or 10 certified artists a year or even less, I'm not sure how the city could suddenly process 4,000 or more applications. And it certainly would seem very unfair to be imposing fines when people are in the process. Also, I mean,
That question, what's end of the question there was?
The question is how could you actually even do it as a city agency
Okay.
if right now you meet twice a year and you actually have a pretty high criteria. My understanding at the time was you had to be held in global collections or museums. My husband's work's, you know, held at the Smithsonian and the ICP and other. I'm not sure what the criteria is, but it's not like everybody that's an artist. So, you know, I'm not sure how clear everyone is from the city on what the criteria are. And certainly, you know, when you have NFTs coming out as artwork today, that would certainly not be included in the definition of art before. So just from a very practical perspective, it seems quite implausible that any definition, unless it were really updated today, and also had a bureau that is qualified and able to define this and process it, it just doesn't even seem like people could comply, even if they were going to try, based on the current status of the city's, you know, system. So my number one question is, you know, that, you know, how would you even do that? The second one is, you know, when you look, I am confused on what the intent is, because generally the having a fine and not enforcing it, the whole reason that this has not really been addressed for so long is because everyone knew it wasn't enforced. So even if you raise the fines to 2 million, if you're not going to enforce it, it won't change behavior. So if you're saying you're trying to change behavior, then what behavior are you trying to change? And that's where I'm most confused, which is my macro question, which is, what is really the objective here? Is the objective to support artists? Is the objective to have conformity with law? And if it's with conformity with law, then why not just get rid of joint live work for artists and grandfather everyone, make everyone residential, and then we're done. No one was penalized. And then, you know, so I'm just confused on why you would go through a process that would definitely penalize the most vulnerable and create with a system that is not set up to even process it. And I'm not sure what you yield then. So
hang on one sec before you ask your third question. Hannah, do you want to respond to Coral's first two?
Yes, thank you. So Coral, first of all, I put in the chat the DCLA process to become a certified artist. So please check it out. It will give you all of the answers to that kind of question. And the intent is to get folks to comply, whether that be converting to residential or selling to a certified artist. I think someone else brought up the point of like all of these fines. Well, there are no fines if you are conforming with the usage, if you are a certified artist. So that is one great way to avoid the fines. And about your other point was how will the city be able to process 1,000 certification requests? Well, right now, like I said, there's only been 4 or 5 applications in the last year. So definitely please apply. They have the capacity to take on many, many more than that, but they just haven't had any applications.
So I'm still confused though, because what you said on the first one was that, you know, you're trying to get conformity, but again, to what end? Are you trying to, get more certified artists into Soho forever in joint live work quarters? Or are you trying to just get everyone to have the legal status of the zoning in Soho conform to current use, in which case you could just say everyone's residential and we could literally be done. So, if that's the objective, is to get everyone to conform and you're not trying to penalize anyone, I'm confused on why the bill isn't just to say, we are now going to convert, because that was a very dated and out of date definition and use, and the neighborhood is involved tremendously. Everyone that's there now is residential. And then we move forward. That's my question.
Is that, sorry, Coral, was that your last question?
Yes.
Thank you. Hannah?
So Coral, if your question is what my entire bird's eye view hope of the entire bill is, again, the bill specifically is just to raising fines, because that is one way that we see to incentivize people to conform. The bill is not going to be a magic bullet with solving a lot of problems with the, just the way that the zoning laws are now. It's not going to, create this is just one small part of it. And I think
Meaning
that
the land use or the
Well,
background?
you could achieve this though by just, if it's the conformity, you could achieve it by just literally having the bill transfer everything. The only thing you achieve differently by the penalties is possibly creating a revenue source for the city. And if that's what your objective is, then I just would like you to own it. And if it's not that,
well, right now, if you want to convert from manufacturing to residential, that also would generate $100 a square foot for the artist fund. And
But
Soho
why-
known to be
why
an
would we even be doing
artistic
that?
neighborhood, and that's why we want to make sure that arts and culture are supported in that way. I know that there's a theater in Soho that is kind of faltering a little bit. We want to see a lot of money go towards that, and we want public art to be really, really strong. And so that is a
No,
way
but you're
that the
taking
city
away money
has
from artists.
opportunity to
Okay,
give
okay,
money
Coral,
That is city
Coral?
agency. It's not.
Thank you,
Sorry,
Coral.
this
Coral,
is just.
sorry. We're here to just listen to her answers. It may be hard to take.
Thanks. Also,
Sean,
Coral, if
did you? Sorry, Kenna. Go ahead, Kenna.
Never mind. I was just going to say, you have my contact info. It's in the chat. And if you are conforming in the right way, then you won't get fined.
All right, but Kenna, I want to encourage you, as much as you want to hear from people, it's good to hear their questions, but if you're disseminating information, it's really, I hope that you'll consider doing it in a way that reaches the greatest number of people, not on a one-to-one basis. So Sean, you have your hand raised?
Yeah, thank you. Thank you very much. I have 3 questions for Kana. You said you gave a link to DCLA. You said it will explain everything. Will it explain how an artist I know applied? She didn't believe in the gallery system. She just sold to friends, so she was not known, and she was denied artist certification. And then when she complained, she says, "Can I show you my income tax, which says I'm an artist?" They said no. She appealed, and that different person said, "Well, why don't you show us your income tax?" Will it also explain how someone like Andre Balazs, who owns hotels and discotheques and who's married to the wife of the Ford Model Agency and dates Uma Thurman, has nothing to do with art, how he got certified? Will the DCLA will this website explain that?
You can send all of those particular questions to me, and I will
Well,
ask
let's answer
them
it now.
directly to
No,
DCLA.
please answer it now. There's 100 people here waiting for an answer.
Don, have you read the link yet? Because maybe it does answer some of your
Will it
questions. I'm not
explain how
sure.
Andre Balazs got a certificate and Penny Grill didn't?
I mean, if it
No, it
says.
won't. I'll answer your
Well,
question.
I'm sorry. I'm
Everyone
sorry I
knows
can't answer a specific thing for you. And I really, really want to make sure that people who have specific questions that will be very constructive in making this a bill that works for more people, I want to hear those folks, but I can't answer those random specific things you have. I can forward them to DCLA, and I'm totally, totally happy to do that.
All right.
Well, I've
Sean,
been
do you,
here
are your
40
other
years,
questions
and I'm
more
telling
general?
you,
Sean?
the DCLA process is so baloney. It's a joke. Everyone knows it. Okay, my
Sure,
second
and you know what?
question
We
is-
should definitely widen the definition of an artist, and that's something that I would love to work with the state on.
Okay.
I agree that it's too narrow, so thank you for that, Sean.
Okay,
Was that your,
I have two other questions, but much
Sure.
simpler. If in my building, one person, a shareholder, is renting to a non-artist, therefore they're liable to a fine, who would get the fine? The shareholder or the co-op?
Whoever owns the unit would get the fine. I think that's the precedent for a lot of bills about housing. But again, that is something that I am happy to really underline in a version A of this bill, which would mean revising it and amending it.
No, as far as I know, C of O violations go to the co-op, and I'm the building manager. So anyway, the third question is just a second. Oh, a lot of us moved in here. We didn't even know about artist certification. I was living here several years before I knew you had to be a certified artist. My landlord had no idea. So in 1987, the city grandfathered everyone who was not certified. So I'm certified, but I don't have any papers to prove it. Will I be fined because I'm not a certified artist and have no papers to prove I'm grandfathered, although I've lived here 41 years?
That's a great question. I will reach out to you so I can get the specifics of your case and make sure that I can answer your question.
Well, there are hundreds of us like that. I can mention one
Okay.
on this site right now who are not.
Perfect. So then I want to help everyone in that situation. I really do, Sean.
Okay.
So I'll reach out to you and I'll email you. Thank you.
Thank you.
so I'll call on you in a minute, Carter, but following up on what Sean just said, when it comes to legalizing retail, when there's an absence of documentation, the city always leans towards accepting the existing condition and really with minimal or no penalties. So have you given any thought to expanding the council member's bill to include all types of non-conforming uses in Soho and NoHo? With increased penalties and actual enforcement?
Are you talking, so extending it past just residential into commercial use?
Well, yeah, I'm thinking about when, I'm thinking about all the oversized retail people who've never gotten the necessary variances or special permits. I'm thinking about when Zara came to us and there was no paper trail on their certificate of occupancy. And the city just said, oh, that's okay. You're there now. So we're just going to let you be legalized as kind of an existing operation. So that's basically what we have with all the non-artists who are living in artist housing. Gave Zara, the city gave Zara a pass. Why are we toughening up on only one sector?
I don't know about the Zara case. I will have to look into that. And
Well,
I'll
the
be
Zara
happy to
is
get back to you.
only one case of many, right?
So currently the bill, thank you, Frederica. So currently the bill is only about residential, but I'm happy to talk to some of my colleagues who might know more of the specific case and see if it could be applied to commercial.
Right,
Thank you
because, if you're looking to generate money, let's generate some money. Carter, you have your hand up.
I feel like I'm a bit in the twilight zone here. The Envision Soho NoHo report lays out most of this stuff. We worked on that. Your office was a sponsor of that bill. The mayor put forward his rezoning plan. We got that. Doesn't really look at any of the local residents, which are your guys' direct constituents. This bill goes after your constituents in Soho and NoHo. You're focused on the penalties and not on helping people to resolve their issues, which have been going on since the 80s. And nobody, from my understanding, has ever reached out to the city electeds, to the state electeds to work on this, the mayor's office or your office. And we're now in well beyond the 11th hour trying to solve something. And nobody pushed DCP to resolve these issues either. And I'm not sure why all this attention is going on this one bill when the work should really be on the open issues of conversion and if that's even possible. And that's been raised over and over again and just ignored. And my understanding is you just had your first meeting with DOB within the last 2 weeks.
What is your exact question on that, Carter?
Most of this is outlined in the Envision report, which is 2 years old. your guys' office was a sponsor of that. This is all laid out. I mean, these issues are not new. There's no resolution to them. DCP and the mayor's office didn't make this a priority, and now we're talking about penalizing people and not solving problems. And rezonings are supposed to solve problems, not
Yeah,
create
well,
them.
this bill is not a rezoning. This is a bill that is an introduction, can be amended. It has no, jurisdiction over what DOB can do in this instance. That would be an entirely different bill. And that's something that, again, like I said, we are working with the agencies to try to make it easier for folks to comply. That is
bill-
one of our priorities.
The
We
bill
just haven't
specifically
filed an
says
LF
it
zone.
goes, it's tied to the rezoning. I mean, it says
Yeah.
that right in the report on this, that it's a part of it and separate bill, but I don't understand how you can disconnect them now.
Sure. It is part of the rezoning, but it's not, like I said, it's not the be all end all. It's this very small part of a very, very complicated process and a very complicated scenario that we all find ourselves in. So,
So why aren't you working on the underlying problem, which
I
is
am
not
working
just
on the
artist
underlying-
certification, it's the evolution of whether or not units can actually be converted to residential. Nobody's studied that, period.
Okay, well, what I can say to your, I guess, question is that we are working with agencies and making sure that the information can be disseminated to the right people, and it's a process that is understandable and can be resolved within a normal amount of time so that people can comply. Again, I'm going to say that if you are a certified artist, that there won't be fines. Of course, with the caveat that it's perhaps too narrow of a definition to be an artist. But some of the processes, like becoming a certified artist, that is what we can help with. To some of your points, like what are you doing to make it easier for people to comply? That is what we're trying to do. And
Yeah, but the biggest
more
part is the
information-
people who can't become artists.
Okay, yeah, I agree with that, and that's something the state needs to help with. That is what I can
No,
say.
that's not the state. That's not the state. If you can't become an artist, it's the whole underlying conversion problem, which this rezoning is allowing residential, and nobody's looking at how do you convert to residential. So all the non-conforming tenants who've been here for decades, not just a minute, can become conforming. And why is that not the focus
Great.
right now?
Okay, so like I said, when we were looking at some of these possible amendments, one of the things I mentioned earlier was perhaps like a sunset provision, or maybe looking at who has been here for a really long time. Who are the people that, quote, made the neighborhood? Maybe there's an opportunity to, maybe if you've been here for a certain number of years, that's a pretty good compromise to say if you've been here for like 10 years, for example, you won't be subjected to like maybe a large percentage of this conversion fee. That's something that I'm willing to play with, and that's something that I'm looking into.
All right, Kenna, I think everyone's questions really have kind of lifted the rock on all of the areas that moving ahead with this bill just seems premature. Janine, would you like to unmute yourself and ask your question?
I just want to sort of echo what Carter said. I mean, we've ripped the Band-Aid off the legislation, which pushes us back to the rezoning, which was the second agenda item. And since you're the Deputy Chief of Staff to, the main council member that covers the majority of this area, the real question is this was the slide that Anita shared earlier, that the city planning had their slide on October 4th that basically said, adjust the special district to ensure seamless JLWQA to residential conversion if voluntarily sought. We did invite DOB tonight. They were unable to come. We know City Council land use has only been meeting with them, I guess, in the last week. So we're at a situation where this is the 11th hour. There's a rezoning on your plate. CB2 has a clear position on it. But specifically with JLQWA, the city says it's going to ensure a seamless conversion if voluntarily sought. So can you explain how that would work?
Sorry, can you repeat the last part of that question?
I'd like you to explain the seamless conversion, the seamless and voluntary conversion from use group 17D to use group 2 as currently proposed in the rezoning that's been, in discussed, counting Envision Soho NoHo for 3 or 4 years.
Oh, sorry, I was on mute. Honestly, I'm going to have to talk to land use and get back to you on that, especially with the use groups. I just don't want to confuse two of them together. And I'll have to talk to Anthony as well about that.
Right, I was
before-
actually just about to
Yeah,
jump in on
Anthony,
that.
can you want
Maybe-
to jump in on that? I know this is more.
Yeah, because that falls in it now. But again, I'm gonna defer we'll have a conversation with the land use team on that from the use group change that you're specifically speaking about. We'll have a talk with them about that.
Honestly, when
can-
if you have your talk, I think it would be helpful for us to share with you the transcript of the chat. And so that you can record all of and deal with all of the questions that have been asked. But I would like to go to the attendees. I see 4 hands raised. And I'll start with Gil Traub. Would you unmute yourself and speak?
Hi, good evening to everybody. Thank you all for being here. I think it's a wonderful conversation with a lot of very smart people. I've been in the area for 27 years. When I bought at the building where I'm the president at One Bond, I signed an artist in residency waiver, and it was presented as nothing more than a formality. And everybody who lives in this building is the same. There were artists here. Some of them died. Many of them actually capitalized and sold their apartments and retired, and they were able to do so. If this legislation goes into effect, bless you.
Thank you.
It's not just going to affect those of us that have been in the community for so many years and have done our part to beautify and make it better, but it's also going to affect artists as well who want to retire because they're not going to be able to sell their units. In our case, we're planning a whole restoration to renovate our building, our facade, which is a beautiful landmark building. And now our board does not want to do that because they're afraid that we'll get sucked into a $2 million renovation and there's no out strategy. And that's a problem. I mean, and also I spoke with Carter a few days ago. I'm with Cordelia on the NoHo bid. I love the area, care about the area. I do what I can for the area, but I only heard about this 2 days ago. And it couldn't be a worse time to propose this legislation during COVID. People aren't working. People are not of a sound mind. They have other problems to deal with. And now this, and I just want to know, understand this can be tabled and discussed, revisited, because there's a lot of questions that just cannot be answered. There's a lot of uncertainty here, like Carter and other people have said, renters, owners, who gets the fine, who doesn't get the fine.
All
Why,
right,
so
that's your
that's
question.
that's my question. So I don't mean I'm rambling on, but there's a lot to sort of get out in 2 minutes. So that's sort of my question there. Can this be tabled and revisited at a later time?
Thank you. Kana?
If you're asking if I'm going to withdraw it, then the answer is no.
Okay, thank you. Paul Schinkel?
Okay.
You have your hand raised? Unmute yourself. Paul? Paul? All right, let's move on to Amit Solomon. Amit?
Just wanted to, can you hear me?
Yes.
Okay, good evening and thank you for convening this, very important. So
We're
first of
asking
all-
you for your questions, Amit.
yes. I've lived in Noho for 14 years. I'm raising 3 children here. I've been on a conference call with Margaret Chin and her staff earlier this week, where people here were referred to as illegal, violating, abusers. I heard you call people flippers. We live here. If you put this in criminal terms, I am a criminal. I am one of these criminals. I live here. And you put a bullseye on my back now with this legislation. You want to kick my kids out of their home, including, and not just my home, there are about 1,200 people, 1,200 apartments that are de facto apartments. And you want to evict them for what reason? It's not going to help affordable housing. It's not going to help any of your goals. It is purely vengeance, punitive. You believe that we are Bon Jovis living in penthouses? We are not. We are working families. We came here to raise kids, and you are after us right now. That is unfair. And I have one technical question. If this is part of the zoning, where is the supplemental EIS for this new legislation?
Hannah?
Thanks. Yeah, and I remember talking with you on that Zoom earlier. Great to hear from you again. I know you brought up the thing about your kids on our last Zoom. Obviously, not our intention. We're not proposing to like kick kids out of their home, but there is the reality that there is a law in place, and we do have some units that are not complying with that law. So that is something that we are working to remediate. And like I said, only 12 instances of people paying these fines, or at least being given these fines in the last decade, and they are complaint driven. So unless someone is filing a 311 complaint that Amit is living illegally in a unit, then DOB is not going to come and like knock on your door. So I think that's just what I can say about that. But
so there's a law in New York City that you're not allowed to wear slippers on the street after 10 p.m. There are many, many laws that are not enforced in the city. This law has not been enforced in 30 or 50 years. Why now? Why just JLWQA, not all the other non-conforming users in the entire city? And why has there been no supplemental EIS?
I will have to get back to you on the EIS. Maybe
Well,
Anthony can speak about that.
Yeah, I'm going to respond because this is a legislative driven. This would not require a supplemental environmental impact statement.
No, it does, because you're joining it with the rezoning, so it has to have
No,
a supplemental EIS.
this was actually drawn up separate from the rezoning. The rezoning is moving separately from this. So this would not require trigger a supplemental EIS.
It does say on page 1 in the first paragraph, it's related, but I guess related doesn't.
Related is a different category than actually,
Exactly.
yeah,
Mhm.
so no.
When it was presented in a public hearing on November 9th, it was presented together. What we heard from Margaret Chin on Monday is that those are together. What we heard from you tonight is that those are together. They're joint in purpose. So why is there no supplemental EIS if this is part of the rezoning?
Okay, you asked a question, Amit, and she gave you an answer. And if you still have the question, please send it to the address of the
Thank you.
CB2, info@cb2manhattan.org. .nyc.gov, not org, gov, I think it is.
It is .org.
It is then I put it wrong in the.
I put it incorrect. I'll keep editing it.
Thank you very much. Paul Schinkel, is he here now? Okay, how about Pete Davies?
Yes, thank you. Connor, I sent you an email on November 12th with a number of questions about this bill. And so I'm glad that you're here tonight. I haven't received a reply. I have 3 questions in my email to you. One is about the lack of a financial analysis for this bill, which, reading the New York City Council guideline to legislation, a financial analysis seems to be required. So I'm curious about that. Second, the notice for the hearing on November 9th. This bill appeared out of nowhere on November 8th. And I believe the late afternoon of November 8th was the first time that anyone had heard of this bill. So I'm curious about the requirements of a notice of hearing that took place the next day where it was not presented. So I'm curious about that. My next question was about the next steps, which is what we're dealing with now. But my one question for right now is reading the committee report for this bill. On the third page, second paragraph, states the desirability of the Soho NoHo area has made the market for JLWQA units so strong that these units have been sold to non-artists, contrary to zoning. Now, is it your understanding that it is a requirement of the zoning that a JLWQA unit must be sold to an artist?
That is currently, I think, what the zoning is putting into place. Like, that's what these units are originally for artists who are looking for joint live work orders.
That so therefore your position is that the transaction of sale must require the involvement of a certified artist.
I think the point of the statement you said is that, yes, they're selling for so much money that non-artists are buying them for like millions and millions of dollars. So what is your exact question on that part?
My question is, if there is no requirement that it be sold to a non-artist, then the sale to a non-artist, the sale has nothing to do with the zoning.
Well, just because you got away, like someone got away with breaking the rules doesn't mean that.
Rule that requires a sale to an artist.
Okay, if that's a technical question, then I can't answer that right now. What I'm hearing is, should a JLWQA be sold to an artist? My answer would be yes. And if not, then it should be converted and the person should go through the conversion, the whole process with DOB.
So I put you on the record stating that a sale must be to an artist, and that is the basis of this bill. And this bill,
no, that's not the basis of this bill.
Well, it is your stated goal that the sale must be to an artist.
No, I'm sorry. That's not, I feel like you're conflating a lot of things, and I'm going to have to answer that offline because I'm kind of confused.
You know what, can I just jump in here? I guess he's quite wondering, does the law, the way it's written, are buildings required to, are JLQWA units required to be sold to an artist or only occupied by an artist?
So the bill's intent is to increase the existing fine. That's what it is. If you're having questions about like technical things related to the sale of JLWQA, that's completely different. I'll have to answer that at a later time.
I really think you'd be well advised, if you're not sure, not to go any further with that, answering that question, Kenna.
Great, that's exactly what I just said. Thanks, Frederica.
One more point, guys. This committee report went through the legal division of New York City Council. The names are at the top of the 5-page committee report. This was cleared by legal. So if there is a mischaracterization of what the law requires, that is not just a technical thing. That evidences a real misunderstanding of the situation in Soho and NoHo. And
I'm not the bill drafter, and I actually don't draft any of these bills myself because I'm not a lawyer, but I'm happy to ask the bill drafter for any of these, to answer any of these technical questions that you might have.
Okay. Just one more thing. You just stated, and the transcript will show, that the sale, and this was before I asked a question, that the sale was to an artist is part of the requirement. Selling to a certified artist.
When you say requirement, are you just talking about JLWQAs? Because they are intended for artists for joint living work quarters.
But not as ownership.
Not as ownership? What do you mean?
Meaning a artist is not required to be the owner.
That is a technical question. I will have to get back to you on that. I'm not sure. But on that note, thank you so much, Pete, for your question. Janine, I did tell you earlier today in a phone call, I do have to leave at 6:30. But thank you so much for your engaging dialogue. This has been a great time to hear everyone's point of view. And my information is in the chat. Thank you.
Hannah, are you leaving right now?
Yep. Yep.
All
I did
right.
tell
Well, thank you.
earlier
Thank
today.
you very
Sorry
much for
about that.
coming. Thank you very much for coming. And we will get you the transcript of the chat. Anthony, there's just a few more questions. You think you could either answer them or follow up?
Yeah, and
yeah,
if,
I'll
Anthony,
stay
if it's a
on.
legislative question, feel free to defer to me and just give them my contact info again. Thank you. Thank you,
Okay.
everyone.
Thank you,
Thank you.
Hannah.
Thank you. Bye.
All right. Eugene, you had a quick question, right?
Yes, I actually had two quick questions, and I wish Hannah could have stayed a little bit longer past the 6:30 time, but I'll direct it to Andrew or whoever else can answer it. My first question is about how many units of the JLWQA, in the area does, the council member's office think are non-compliant? Is there a number that you believe are to be non-compliant?
That's a good question there, Eugene. I'm going to get back on it because that's actually something we've been trying to get from DOB to get that number from. So that is definitely something on the list, and that's actually a question that has been asked and raised. So I made a note of that to get that answered.
Okay, good.
So
And Eugene, your other
Okay, and I have a
question?
second question. Second question is, did I hear correctly from Hannah that a 311 call would trigger the enforcement of this against a non-conforming person? I'm assuming the 311 call would come from a neighbor. Is that true?
I didn't hear her say that unless she
Oh,
referenced. Okay, then yeah.
Yeah, she said,
I'm
I
hearing
heard her
other
say
people
that
nodding.
there were a dozen calls over a decade and that they came from 311.
Right, okay, yeah. And that was some information that she was able to get back from in terms from what DOB has been able to attain over a period of a decade based off of calls from 311. That's what
No, I think this was more in relation to, and I'm trying to find it in the transcript. I'll find it later, but she did say this very recent, just in the last 20 minutes. So she said this would trigger the enforcement. And so I'm just wondering if this is some kind of, ability for neighbors to snitch on other neighbors that they just don't like. I mean, that seems like that would happen.
Well, seems like it too. Thank you, Eugene. John Paul? John Paul?
Hi, thank you. Yeah, that sign off, I guess, was a little jarring. I haven't seen something like that from some elected official's office in a while. I assume it was just maybe that particular question got to her some with her schedule. But my question, I guess, is to whoever can speak from the office. What type of campaign have they done to inform those who are out of compliance? I don't know why they're jumping right to the fine aspect. I know it's been an open problem for a while. I haven't heard much about campaign to inform and maybe a campaign to educate those who are out of compliance about how to most easily get in if it's such a simple process as was outlined.
Okay. As far as I know, John, to your question there hasn't been and I want to make sure I understand your question correctly, like campaigning, informing tenants and residents that this was coming down the pipeline, so to say, informing about this proposed legislation, correct?
No, not the legislation. If
Okay.
the idea is to incentivize those who are living in these units
Mhm.
who are maybe out of compliance,
Okay.
what steps have they taken previous to this to incentivize those people to actually get in compliance?
Okay.
Or are they going right to putting a gun to their head by leveraging the fine to 15,000? Or previously, did they say, hey, you might be out of compliance here. Hey, your unit's maybe not in compliance. Hey, here's the process for it. Did they try something short of this?
Got it. Okay. That I will have to find out. I'm not aware of it. But I will definitely bring that up.
Okay,
That
thank you.
question.
Ingrid Wygand? You have your hand raised?
I want to tell you that I received one of the very earliest artist certification, but I greatly doubt if anyone could find it. Secondly, why is this legislation requiring an artist certification that has the requirement to exhibit and have income? Probably half of the genuine artists in Soho have neither and would never qualify for certification. So it's the city's definition of artists that is really here, and that has to be considered.
Thank you, Ingrid.
Okay. Thank you, Ingrid.
Renee Montrose, you have a question? Unmute yourself.
Hi there. Can you hear me?
Yes.
I have a couple of questions. I was hoping Kana would still be here. So one of my questions was one to her. But my first question, was about the conversion. They talk about the seamless conversion, and we know that there's nothing seamless about it. But in some buildings, such as mine, 542 Broadway, and one across the street, 543 Broadway, conversion is probably utterly impossible based on what we've learned from the zoning codes, the building, DOB. So there is no way for non-conforming artists here to cure themselves of any violations, except by selling. So, and I imagine that's true of a lot of buildings in Soho. I think there are probably more buildings that cannot be converted than those that can be. So what is the pathway for those people? Is the only option for them to sell if they are not artists? That's one question. I don't know if there's anyone here who can answer that. Anthony?
Yeah, I can't honestly answer that question directly. That's a good question. But I can't answer that. I'm making a note of it, Renee, because that is, and I know we've spoken before on
Yes,
that.
I know.
Yeah.
Okay.
And then I just had one more thing to say, and this was for Kana, because she keeps talking about getting in touch with DCLA and the process, and it's all so easy. Well, she mentioned a letter that BRC had been sending. We've sent that letter multiple times. We've made phone calls to the office directly to Kendall Henry, who is supposedly in charge of artist certification, and we have gotten 0 responses. Clearly they got the letter because she mentioned it, but they did not reply to us. So no one, I have a friend who's been calling them to try to get information about the application itself, who would like to apply. Absolutely 0 response. So how are people supposed to do that? I know you can't answer that. That's just, I want it in the record. That's all.
Okay, thank you, Renee. Laura Tenenbaum?
Hi, thank you. I sent you my questions and a lot of them were already asked, but I'll just go through them again.
Well, you know what, if you sent them and they haven't been.
Well, I want Anthony at least. I want it to be on the record verbally because on the transcript as well. I'll be fast on that because I have something else I want to say as well. But I'm I am not the artist in my JLWQA, my husband is. And it's, what am I going to do? Get a letter that says, sorry for your loss if my husband dies, but get out or else pay $15,000 right now? I mean, this law as written has made a lot of people very worried. It's a cruel law as written right now. My co-op has never had a sale to a non-artist, but we do have non-artists who inherited a space living here. And that non-artist is somebody who I think that anyone would agree is a perfect person for our community. He's a refugee from Rwandan ethnic cleansing. He lived in Central Park for the first year in New York City. And he now runs a nonprofit in Burundi for women, a nonprofit hospital for women. He inherited this place, but he would not be able to afford buying it. And he wouldn't be able to afford paying any of these fees. And our co-op couldn't either. The truth of the matter is we had to double our maintenance fee because we had to fix our building. These are old buildings, they are expensive. To say we have to go back to what we paid for it in 1973 is insane. And I've been reading those comments that say that amongst some people. And because the costs of everything have gone up and we have not become wealthy on this. We have kept treading water and we still tread water on this. And these onerous fines and everything else are going to hurt the middle class and the lower middle class, and not the guy who just paid $47 million for the JLWQA in the building next door to me.
Legally.
The LLC. We spoke, Sean brought up the grandfathering program, which is not in there. I'm absolutely flabbergasted at the level of ignorance of the people making the presentation, and even of the city council lawyers, that they don't know about the grandfathering law, that they don't know about the difference between occupancy and ownership. It really, really, really does disturb me. This whole thing disturbs me. I think this is a way to just punish us for being artists and living in Soho. They want us to get out and they want us gone. That's all.
Thank you, Laura. Going back to Paul Schinkel for the last time, did you want to speak, Paul? Okay. Michael Levine.
Yes, one question for clarification to understand if I heard correctly. This bill, this amendment to the current bill will not be withdrawn, but is there a timetable or not? With all the discussion that's happened, I really didn't hear the answer. Is there a timetable for adoption? Does this community board need additional time to consider and to determine what our recommendation or our opinion would be? What is our timetable? I didn't quite hear that clearly.
I'm just going to jump in here on timetable. There are two agenda items tonight. One is the penalties and pathways. So the penalties that were proposed in legislation and the pathways to the pathways to a seamless voluntary conversion. And obviously that was the question. That was one of the many questions that we've been unable to get an answer to tonight. So I think it's our understanding, and I guess I'll go to Anthony, is our understanding that the rezoning, and who knows what the legislation might be delayed, but the rezoning will likely be getting some kind of city council vote next week. So if there are the lack of seamless voluntary conversion options, the question is, like, we'll probably put together a list of all our questions and send them to decision makers. But is that still the timetable, Anthony?
The council is not voting on the rezoning next week.
I meant the subcommittee.
There will be a subcommittee next week.
Yeah, and that's the yes.
But I did hear Kana say that she was open to a delay.
But that would not be for the rezoning. That would be for the legislation.
No, for the legislation. You asked what the timetable was.
Yeah.
And so let me jump in just real quick. So Michael, for your question, for that, the delay in the legislation, are you for the board or for us?
Well, no, the question I was asking is, would there be a delay for this legislation, giving this committee board sufficient time to consider the questions, consider the issues, and then come up with a recommendation? And I think what I'm hearing is there is no set timetable for adoption of this
That's correct.
amendment. So therefore, we really don't have a time. There is a timetable for the Soho NoHo rezoning. We know the council subcommittee will be considering it next week, but there is no timetable for this legislation, which would give this community board sufficient time to determine a recommendation with the issues and concerns that we have. Am I correct, Anthony?
That's very correct. You're absolutely.
Thank you.
All right, and we've got that. But did you also say, Anthony, that there would not be a vote on the neighborhood plan next week?
Oh, no, for the rezoning, because I was answering.
That's the neighborhood
the
plan.
city council as a whole was rezoned, but the subcommittees will actually be voting next week, not the city council as a whole.
The subcommittee will be voting on the rezoning next week.
Correct. The land use subcommittee and the full land use committee next week.
When does it go to the city council, Anthony? What would the
Well,
timetable
if it's happening, if the subcommittee's voting next week, I would imagine the following week, because we only have about 2 or 3 stated council meetings left. So, because remember, Christmas is the week of the 20th, and everything is up a week.
Okay. I saw that Gil Traub had his hand up again. Gil, you had something more to say? Or
Yes, I've got a question for Anthony here, and only because, I want to report back to the board members in the building. Question 1 would be, if this legislation passes, and let's assume somebody who's not a certified artist wants to do a renovation to their apartment, would they get permission from the DOB to do that renovation? And question number 2 would be, if this legislation passes, let's assume there's 2 neighbors who get into a fight with one another, and somebody decides to call 311 and say, you know what, I don't like this guy. He's not an artist, a certified artist. Do we get into a situation where people rat on each other so that this way there's violations imposed on them?
Oh, that's a tough question there and hypothetical, Gil. Part of me doesn't. I want to answer, but then I don't, because I don't want to give you or anyone on here any misinformation or misquote for. I mean, to the second part of your question relating to 311, I mean, anybody who calls a 311 calls, and if it's a consistent amount of complaints, will trigger a response. That I do know. But to your point of, if this is going to get to a tit for tat, with neighbors snitching on each other and ratting each other out, I can't really say on that. I mean, that actually honestly would depend on the neighbor themselves, if that's going to be something that will happen, if a neighbor will continue to call 311. And only those type of calls I understand from 311 when I hear and receive information, if it's for some like major violation, noise issue there, not so much because of a neighbor that they may or may not know and may not be an artist, just just ratting them out just entirely. I never heard of anything related with a 311 along those lines. So, but that's just my own type of thinking, nothing like professionally, like, so
Because from what I'm hearing, from what I heard from the deputy, to the councilwoman, is that 311 calls will get the DOB to act. So if there's 2 neighbors who don't like each other, and they could both well not be certified artists, all it takes is 10 calls to say there's a non-certified artist living next door to me. And the next thing you know is that person now has a $15,000 fine. But more relevant is, how will this be treated if somebody wants to renovate an apartment? Will they get a permit from the DOB if they are not certified artists?
Yeah.
Okay.
That's a good question there. Let me, I'll make note of that, Gil. I'm gonna refer that back.
I'm sorry to throw you on, like.
No,
but
that's
I have to report back to my board
right.
tomorrow.
No, that's a good question there. I'll make a note of that.
Okay, thank you. Elliot Barowitz?
Yes, I'd like to, what I'm really concerned about is, why did the city drop the ball on artist certification for Soho Winnow? They certainly did that. I was an original member of the Artist Certification Committee, and I've been sitting on the New York City Law Board for about 15, 18 years. So I don't know if anybody can answer this. So you dropped the ball, the city dropped the ball on artist certification, and now they're planning to penalize everybody. That doesn't make any sense to me. I think those funds that you're wanting to get for penalizing people should be disregarded, should be taken out of the Soho NoHo rezoning. And besides that, here we are talking about Soho NoHo Chinatown rezoning, and we haven't said a word about the rezoning and how that would happen. So can anybody there, Anthony? I once spoke to you after a meeting in NoHo, and you said you would get back to me then, and you never did. So I wonder, could you answer or try to answer, why did the city drop the ball on artist certification? And now it's penalizing people?
Yeah, and Elliot, I recall that conversation. I, again, was trying to reach out and have that same conversation which you had with me with DCLA. Look, I can't actually answer that question directly. I can't say why they did. That's something I don't know, and I have yet to get that response cleared up. So I can't answer that. But you know, I'll make the push again to get that clarified. I know that's an answer that you all are entitled to, but I can't answer that directly offhand.
What was his question about?
This was,
Oh, he said the city dropped the ball and they're going to penalize people.
his question was,
Certification.
why not just stop doing stuff?
Yeah.
All right, there's one more hand. Oh, okay, Dror Schneier.
Why don't they just drop the A?
Dror Schneier.
Margot, they were supposed to be there tonight, idiots.
I think somebody has to mute themselves. Dror, you there?
Yeah. How about now? You hear me now?
Yep.
Okay. I've been here about 40 years. When I bought my unit, my neighbors were rats and drug addicts. And the building that I was living in, a 12-story building, was paying about $50,000 in real estate taxes. 40 years later, and this is my attempt to answer the question from the previous speaker, the reason why the city didn't do anything is because the city was reaping an enormous benefit from allowing all these units to be developed and constructed. And now my building pays $800,000 a year in taxes. And it seems to me that this fine is meant to be a punitive fine on those lucky few that had the courage to be here in the late 70s, early 80s. And I just don't understand. On one hand, you're saying, well, we're going to increase the fees, but it really doesn't matter because no one enforces it. Get a life. This is not the way it's supposed to be. That's all I want to say.
Great. Oh, we're raising the fees, but nobody ever enforces this law.
That's what they're saying.
I know. I mean, it's then why do it?
Exactly.
You need to mute yourself, Eugene.
Sure. I just wanted to ask a question that I think was in the chat a couple of times, but it's about the subsequent part, the subsequent fine. So the legislation has the initial fine is, I think, $15,000, and then it's $1,000 a month until it's corrected. But then there's a subsequent violation. When does that kick in, and what counts as a subsequent violation of $25,000?
Okay, Eugene, I'm gonna have to refer that one to Kana. I'm not sure about the subsequent final, but I'll refer that to her.
All right, thanks,
Mhm.
Anthony.
Okay, one more person wanted to raise, Rob. Rob Hootenboss? Are you there, Rob?
Hi, I'm Susan. I'm Susan Rob's wife, and
Okay,
I'm
great.
gonna just speak on our behalf.
Sure.
Thank you for all staying on this long. We have been at every Envision meeting. We've been in every in-person meeting. We stayed the full length of every single Zoom on the rezoning. We were part of the committee's anyway, in terms of our demographic, which is the joint live work, but there are so many of us who are not artists in the first place, are not certified. We have a very creative building that reflects the tone of the neighborhood. I've been living here 45 years on Crosby Street. I've had a business here. I'm a fashion stylist. But everyone in our building, we have a theater director, we have a documentary filmmaker, we have a fine art gallerist, and so forth. It really reflects the nature of really what this neighborhood is right now. I think it was Laura Tannenbaum that was speaking to all the different kinds of conundrums in her building. We own this condominium, all the unit owners do, and we've not been able to get a C of O for 23 years. And basically, you know, the reality is I lived on Crosby Street in another artist loft with my artist husband who still has ex-husband who has that rent controlled artist loft. And, you know, the reality is that, you know, artists really, if we're, you know, most people anyway can't afford a $2 million loft. I don't mean to throw disgusting numbers around, but like how many artists can afford that? And a lot of these artists, you know, who are aging in place, a lot of people are senior citizens. Really the reality is, and I think we should have these numbers at our fingertips. You know, most of these artists who have been at all these meetings, they're mostly in their late 60s, their 70s, maybe even their early 80s. This may represent their retirement, the hope to sell it. It may, you know, represent that they think they're going to leave it to their kids. But really, there really hasn't been enough transparency as to, you know, what the real realities are. As Amit said, we are not all Bon Jovis with, you know, $1 million penthouses. And I do feel like there really has not been enough statistics and work done. And there hasn't really been an opportunity for all of us in these varying measures of distress and, as Laura said, anxiety over this 11th hour bill to really coalesce and come together and work together. I don't think there's anyone on any of these meetings who doesn't agree that artists need to be protected. But really, that bill in 1971 was put forth really, those people, the artists were squatting and living in those, moving into those, you know, manufacturing spaces illegally. So the loft laws were created to protect the people that had illegally, you know, moved into those spaces. And really, I think we're really doing everybody a disservice by not really recognizing that this is a very creative, thriving neighborhood, that the people with money or people who have come into wealth or worked hard or got aged in and have more wealth, you know, that we all live here because we decided we want to be amongst other downtown types. Downtown, we're not Upper East Side types, you know, and so I really feel like, you know, it's not between the finance people and the artists. And I think that we really have not had a forum. There's been so much discussion on hundreds of hours, you know, with developers and affordable housing, and the developers sending people who don't even live in this neighborhood to constantly speak up, you know, who work for them, they're paid. And we've never really come out of the closet with the realities of all of us who live in these spaces and what our differences are and what our similarities are and how we can resolve it, not put, as other people say, at the 11th hour, you know, put a gun at our heads. And, you know, one last little thing, our little loft building has just been hit with a $350,000 bill. We live in a historic district. And because we have to fix some, it's, I think it's called FICA or something. Yeah, FI, anyway, it's the safety facade inspection law. The people in this building are having to absorb a $350,000 expense because this is, you know, because the landmark says that we have to have this. And, you know, we have, sorry, a historical building. And the reality of who can absorb all these expenses is another reality of preserving this neighborhood, keeping the character, et cetera. So thank you for your time. Glad I was able to speak.
Thank you.
Thank you.
John Paul? Anthony,
I'm
did
cutting-
you want to respond to her? I'm sorry.
No, actually, I was just going to mention, because I actually have to jump off and head out. I'm unfortunately sorry. But if anyone needs to get a hold of me, I'll drop my contact information in the chat. But I know I mentioned Federica. If you want to give them my contact number, you can, and email. But I'm gonna have to sign
Just
off.
do that before you get off, okay?
Okay, I'll do that.
All right. John Paul, I'm going to hold your question for a sec. Eugene, did you have something you wanted to talk about while Anthony's doing that?
Sure. Do we still have the slides? If we could just go to that next slide.
Oh, sure, but I don't have your slide. Do you want to share just yours? Oh, I'll put mine up.
sure.
Why don't you just
do that slowly if you don't mind? Anthony.
Yes.
Sorry.
Yes.
do you want me to put that one up and then you put the second one up? I'm
Sure.
sorry. Okay.
No
Just a
problem.
moment. I wasn't ready for that. Sorry.
Do you want, I have it somewhere. I
Yeah,
have
why
it on
don't
my
you-
desktop.
Okay, why don't you do that? Thank you.
Sorry, 1 second. So we had, yes. The other topic we had was regarding the what's called value capture. And I think this is in regarding to the pathway for conversion from 17D to use group 2. And there's $100 per square foot fee associated with that. DCP had a study that they talked about, which is basically looking at the last 10 years of sales. We actually, I think Amit, who's here as well, had to file a FOIL request to get the data from DCP. We had asked for that data before in terms of how did they come up with $100 per square foot. And when we looked at the data, it looked, you know, there were several issues that were kind of immediately obvious. The data, someone from DCP went through and hand marked whether each sale was a JLWQA sale or non-JLWQA or new development. And they excluded new development. And they didn't really take a look at anything else. They didn't look at whether it's a co-op or a condo, the number of bedrooms, whether it's been renovated, you know, walk up, any of that. All they did was take a look at all of the gross sales data. And if I can share my other screen, I'll just give 1 second. The numbers they came up with were used to justify the $100 a square foot. What we saw was that there really wasn't any difference between JLWQA and non-JLWQA sales. We had, let me find this. 1 second. Okay, so we did take a look at the data and we you know, there were several that we had to reclassify. Some they had marked non-JLWQA that were JLWQA. Some of them that they had marked non-JLWQA that were new development. And actually a lot of the sales ended up being JLWQA sales, which makes sense if you really think about our neighborhood. There's very few buildings that are R2. And they tend to be the new ones, the ones that developers bought, completely revamped, and then sold for a lot of money. So on the left here is the data that DCP had that they used to kind of justify the $100 per square foot. They looked at the median price for JLWQA sales, and they also looked at the median price for non-JLWQ sales, which was, I think, about $1,700 versus $1,525. And they said, you know, that's $100. When we reclassified the sales and also took out some of the outliers, like a building, there was a building in there that was a sale, we found that the actual medians were much closer. So the non-JLWQA sales, hold on, the JLWQ sales, the median ended up being like $1,560. And then the non-JLWQ AL sales were actually a little less. Their median was $1,542. Essentially, they were the same. And if you look at the error bars, I mean, the error bars overlap so much that this isn't really meaningful, to be honest. I mean, even with the original data, that you can see that the error bars overlap so much that, you know, one standard deviation up and down, it's not really relevant. You can't really draw any conclusions about whether there's $100 square foot per, you know, whether there's any difference between JLWQA and non-JLWQA sales. There's also, you know, other issues that were found, and I think, you know, Amit can go into some more detail on that, but, you know, that analysis is the basis of the entire $100 per square foot contribution. And it didn't really hold up to any kind of analysis. And, you know, there's about 800 sales they looked at in the last decade. And when you filter it down, it ended up being, I think, like less than 100, you know, R2 sales, and the rest were JLWQA.
I know Anthony is left, but I just want to throw out Iraq, if you could share this with your office, and we'll obviously get this information to Councilmember Chin's office.
All right, Carter, you didn't have, okay. John Paul.
Hi. No, my question was more, I guess, the genesis of this rule. To me, and I don't know why I feel like this, maybe it's because the office who's putting forth the legislation and seeing their history. But I wonder if this legislation is a nice way to have those who speak up against the Soho NoHo rezoning and maybe will stand in litigation against it, that they'll have a countersuit, essentially a fine that's ever increasing against the litigants who were certainly going to be bringing litigation, holding up their plan for this. This is just disappointing. I think it's a meritorious argument to argue maybe, hey, this windfall that has benefited certain individuals who were intrepid early on is maybe something that should be looked at. But to have it go in this way, it just seems subterfuge. And it's just disappointing that it's again out of the same council person's office, who so many times has been on the wrong side of those who she claims to represent.
Thank you, John Paul. Amit, you have your hand up?
Yeah, can you hear me?
Uh-huh.
Thanks again. So I was the one who obtained this information through FOIL, an appeal, and then another appeal. And what Eugene said is right. There is no statistically significant difference between these two groups by any measure. So people say that to accept a statistical hypothesis, you need 95% confidence. The level of confidence here is nowhere near 5%. So this is not, there is no way to draw a statistical conclusion out of this. The data just does not show what DCP says it shows. But in addition to that, if you look at the bottom part of these data, for example, in the blue, you will see deals that happened at $50 a square foot, $100 a square foot. And why is that? So those are not non-arm's length deals. So in my case, when I got divorced 4 years ago, I bought out my ex-wife's share, and that was at $200 a square foot. That's not a representative transaction. It should not have been included in these statistics. And there's an overwhelming abundance of these in JLWQAs, which really pulls down the average and the median. And that's because those are older units. And so life events, deaths, divorces happen more often. So the data is really not cleaned to avoid these data points that are pulling this number down. If they were cleaned, we would probably be talking about a $200 premium for JLWQAs.
Okay, thank you. Michael Levine, you have a question?
Yeah, I just want clarification again on, so where does the $100 come from? If there is such a variance, and if we have different numbers for the sale of units, whether they're JLWQ or not, where does the 100 come from? How is that calculation made? I think I missed something in the presentation. Eugene, could you clarify that, please?
So I think in the original DCP clarification, I think they had referenced a study, and in the study, they had said that they had studied sales for the last 10 years and looked at the median price for JLWQA sales and compared it to the median price of what they called non-JLWQA sales, and they said that difference was exceeded $100. That is the only justification that we found for that number. And there was also a note actually in the comments on the DCP slides that said that they were, I think they used the $100 per square foot and multiplied it by the number of units to try and get $11 million per year. They estimated how many sales would happen. So it's really unclear how they got to the $100. It wasn't really from the data because they finessed the data, and when it served them, they units were classified as JLWQA, and when it served them the other way, they were classified as non. When a lot of the non-JLWQA should have just been new development, which has a premium. Obviously, any new development has a premium in the sales market than a resale, and they included a lot of those developments within the data.
So the theory is that the theory is that if you are converting to standard residential, and you had mentioned R2, I think you meant use group 2. When you're converting to use group 2, you are obtaining a benefit, and therefore the benefit is equal to $100 per square foot, and that's where they came up with the number. That seems to be the only justification I can figure out. You're paying a tax on the increase in the value of the property because you're converting it from a lower sale value to a higher sale value.
Yeah, I just shared on the screen the slide from the September 20th City Planning Commission review session. It's at 3:10:26 in the presentation, and this was their market analysis. They just took the data without actually making sure the data was correct. So this, if you go to September 20th City Planning Commission at 3:10:26, you will see this slide. There you go.
I don't see any more questions. And no one listening to us. So should we go into a business session and just discuss next steps? Does anyone want anything else on the record before we do that?
Have we discussed agenda item 2 completely now?
Well, we did do it in tandem with I think maybe that when we're talking about what our next steps are, we might want to, I mean, we can talk about whether we want to be providing solutions or just bringing up questions. The original idea was just to bring up the question. But I'm happy to, I mean, we have no presentation about pathways because there are none. So I think we will go
Well, I'm
into.
sorry, the only pathway is the one in the current Soho Nova rezoning,
And what is that, Michael?
the $100 fee, the flip tax.
Well, yeah, and we've certainly discussed that.
And we discussed that at great length. And it's an extraordinarily expensive process.
But Michael, they've missed the discussion of the actual underlying process, the pathway. The conversion fee is the entry to the pathway. But
Right.
they've not discussed the actual pathway and what codes or any other grouping. There's no other legislation to facilitate that process. And that's the open question. Just about every co-op board president I talk to, their building architects raise red flags all over the place. And those are the people who are practicing this
All right, can we
particular
go into business
area.
session and have this conversation? Eugene, did you want to say something that you wanted to be on the, you know, before we do that?
Sorry, we do have 2 questions from the panelists, but from the attendees, but my just to kind of echo on Carter's point, I mean, I don't think we had a discussion, and it's a shame that there's no council members or their offices here at this point, but there's been no discussion on any of the code differences, whether, you know, JLWQA units can even be reclassified as use group 2, because there are differing requirements, and how is that, you know, as that's filing an alt 1, which means the entire building will not have a certificate C of O until that's complete. So it hasn't really been addressed whether several units, if they do this in tandem, is one going to block the other. You know, and these are, I guess these are questions that DOB could answer.
Right,
but-
I thought that list of your questions was terrific, and I thought for sure we would include it in our list of questions. But you know, we're not gonna well, unless we want to decide to recommend a pathway, you know, I'm kind of stymied by this part of it.
Yeah, okay. We did have the.
And I just wanted to jump in because it's really so much more complicated in that these are entire buildings, and they're saying individual lofts or apartments, whatever you want to call, file for it to be really not true and incredibly expensive. I mean, we are talking about a lot of money, not just a couple of thou, but you know, a C of O without any problems.
Turn off your video so we get your audio better.
Oh, okay. Maybe I should turn off my mic. Oh, you think if I turn off is that better? Can you hear me better?
Yeah.
Yes.
Oh, sorry about that. I was going to say that just looking at these, having worked on these buildings, not only would it be just a C of O change, is not something you do individually. You do it as a building because of the incredible expense of it. In addition, in order to convert from one use group to another with different codes entirely, there's going to be a long list of variances, also quite expensive, going to the Department of Buildings, you know, requiring a lot of sophisticated help. This isn't something people can do like in the old days. You know, you really need code consultants and lawyers and architects and engineers. And then finally, they can't have a single violation. And honestly, many of these buildings have many violations that have been on the books forever. And it's hard to clear up. I cleared one up recently, which had 18 violations dating back to 1984, a really long time. So it's hugely impractical what they're proposing, really.
But Anita, the question is it feasible for an individual unit, which is illegally occupied, to apply for a change in certificate of occupancy for that unit only? Is it feasible that they can make sufficient changes to make it comply?
No, but the inspection for a C of O involves the entire building. In other words, if the pressure on your gas isn't proper, or you don't have the right, there's a lot of things. I mean, it cannot be done. It's the C of O is for the building. It's not for an individual unit. Yes, you can change it, but you have to bring your entire building up to code and erase all your violations. And that takes years, by the way. It's not like, oh yeah, let me go get an artist certification. It takes years. So it's very impractical. Yeah.
I can't remember the address, but there was one building that we looked at, that we had an application where every floor had a combination of joint live work or not, or rent regulated. If one of those units had changed its classification, they can't cite the change on the certificate of occupancy just for the unit that changes use?
You can, but you have to, but the entire building is part of the certificate of occupancy.
Well,
there's
then
so many.
One of the pathways would be lifting that requirement and making it possible to change the use of a single unit.
Well, that and then the other things. Yeah. I mean,
that would be, being flexible about that would be progress. Carter?
Well, but I just want to point out that some of these buildings are in bad shape. Let's not kid around. These are not, there's safety issues. There's a reason for all these codes. So yes, you could, but who's going to take the responsibility if something goes wrong? So it is an opportunity for the DOT to get people to clean up their buildings and bring it up to code.
Yes, but yes, if that's part of the incentive, yes, but just changing the use group does not make a building a unit more or less dangerous. Carter, go ahead.
Yeah, are we in business session?
I don't know. I just decided we were having conversation. When we go to what we're going to do, then we'll go into business session.
We have one more question after.
Yeah, why don't we go to the question and then come back to me?
Question is from Drawer. Is that, I thought,
Yes.
Drawer, did you want to say something, or was your hand up from before?
No, I want to say something. I want to make sure I understand when you talk about conversion. Is it just a conversion of the C of O, or is it bringing the building up to code? Like in my building is completely up to code. We have a C of O. We have everything. So where's that conversion? What are we converting to?
We're talking about converting a unit from joint live work to use group 2.
I see. So where does the physical part of the conversion come in?
Where's the what part?
The physical part,
There's no physical thing.
Let me just jump in. Yeah, I'm sorry to interrupt, but I can't wave my hand right now. The other thing I didn't mention is C of O is in Alt 1. That's the technical name for filing for a C of O change in use. But many of these existing lofts are laid out such that they wouldn't pass as residential. In other words, whether there's enough light and air for a 2-bedroom, are the rooms big enough? So many, I think, lofts would have to be renovated to adhere to, these are manufacturing live work use. Residential has a different requirements. So not to say it's impossible, but it means filing a renovation before you file for C of O. So it is, these are all things that should be done. We should be given examples so that we have some way of anticipating the amount of work that goes into this.
Well, you're right, but a proper SOHO, NoHo neighborhood plan would have included that mechanism. So, that's where it belongs. It doesn't belong in this legislation. It belongs in the plan.
When we go into business session, we could state that we feel that that is the next step. Whatever happens with the SOHO NoHo rezoning, we believe the next step the city should take would be to create an understandable, streamlined process for conversion.
All right, good. So,
That's already our position,
okay,
Michael.
speaking of converting, watch what happens now. We're going to convert. To
I
business
think we
session.
have one more question, unless she's.
We didn't when I, what now?
Jane Fisher.
Jane Fisher, okay, Jane, thank you, Janine. Jane, did you want to speak?
I'm so sorry. I've been listening intently and I had you in my pocket and I must have hit it by accident. No, I'm good. I'm
Okay,
riveted,
thank
but no question. And apologies.
Okay,
Thank
great.
you. Mhm.
Sure. Okay, so now we're converted to business session. Everything looks the same. And the question is, what do we want to do next? We determined that we don't have to rush because they're not going to vote on it next week. We certainly all heard that Kana was a little vague about what the final form of this bill was going to take and when it was going to be voted on. So my first question is, do we want to do, our original thought was to just create a list of questions because we thought we were under the gun because they were going to be voting. So the first question is, do we feel now that this requires a resolution? Thoughts? Carter? Unmute
I was
yourself.
going to say, I don't think so, because, this is not going to get voted on. I think in time where this bill is moving forward, but I was going to say that the two discussions tonight are intricately intertwined, and the position of the bill highlights the failure, the complete and utter failure of the rezoning to speak to the lack of pathways. And the amount of the fine is really a secondary issue in that they have failed to look at the pathways, and a rezoning, and this is an opportunity to raise this again, to reinforce this, the rezoning should have introduced a package of accompanying host a suite of other accompanying materials that would streamline that conversion from joint live work to use group 2. And the only conversation that's happened was last week in a 3-year process. And I think that we just need to, this is consistent with our position. I think we just need to convey our dismay that the energy that's being expended on the bill is at the expense of the few staffers that are available, that they're being tasked with coming to a meeting about the bill and not working on the other real problem.
You did say that you didn't think that we should do a resolution, and that's what I'm hoping to hear.
No, it's not a resolution. It's a letter. It's consistent. We already have this position. I said it earlier, Twilight Zone. This is all.
I know.
Read
No one
the
is
vision
disputing.
report, routine the vision report, our resolution. It's kind of went back and was telling us stuff like this was brand new. The artist certification, it's right there. It's always been there.
I'd like to hear from other people on that subject.
Yeah.
John Paul?
Thanks. Just thinking.
Talk about whether you think we should do a resolution.
Yeah, so I
Or
might
just-
just say, I don't know what the ultimate right call is here. I just think maybe being aggressive in our response is more appropriate. I feel like we often sit back and wait for the legislation before we take an official position on it. We did something similar to that in Soho NoHo, and in the end, we lost. And they're ramming this through. I think it's a hot issue right now. I think I would at least talk. Maybe it's worth considering putting out a resolution. Maybe there's some traction to it. Maybe it'll seem like what I think it is, as by the media, that it's an underhanded way to get leverage back over, and maybe it'll get some more coverage. I think this is a political fight, and I think we have to fight it as such. So I would think maybe it is worth writing a resolution with our position, so someone knows what we actually feel about this in its nascent days, and not allow electeds to say, oh, we're just going to sit on it because we're not sure what the final thing is. And then just like they did on every other time, they ultimately do what they do to us.
Well, a letter goes out without correct me if I'm wrong, a letter goes out without everybody having to vote on it, and a resolution gets voted on by the entire board, and we have the time for that. Susan, let's hear
Fair
about
point.
you.
I was just agreeing with John Paul in a sense, because I feel like, and even though this is the 11th hour and we can't really figure out what they're doing and they didn't have any answers or usable information, it's not going to go away. And so I think that's part of why it's important to just really be clear about it right now from the beginning and take a position, and certainly list the questions, be clear about what they weren't able to inform us about.
Okay, thank you.
Frederica, can you clarify something for us? The next stated meeting is when, and our full board meeting is when?
Yeah, I mean, had my hand raised for a while. I just want to jump in. I want to take people through the timeline. There's two issues here. There is one, the lack of the pathway, and there's two is this legislation that I don't think we heard anything good about it tonight. That's my quick summary, or the twilight zone. So in terms, I'm going to start with the second, the pathway. That's part of the rezoning. The subcommittee is realistically going to vote on it next Thursday, Thursday the 9th, I believe. Wednesday the 8th. The committee, land use committee meets at 11. We've heard through many sources that there'll probably be a subcommittee vote before that. That is the essential vote. Then the land use committee rubber stamps it. Then they send it to City Planning Commission. They confirm that any changes or modifications are within scope. And then City Council votes. The meeting is, I believe the stated meeting is on the 15th. So this is going to go through
about the neighborhood plan, not
yes,
this.
the neighborhood plan will go through before our full board meeting. So if we want to raise questions about these not seamless, not voluntary plan that's in place, we should send that ASAP. In terms of the legislation, we don't know when it's going to happen. And we can figure out how we want to address that. If we need to, we can have an emergency exec meeting, but our full board meeting is the 21st, and everybody on City Council is going to be on vacation by then.
Our full board meeting is that late?
Yes.
Really?
And even if it wasn't, it would be on the 16th. It would still be too late.
Yeah, yes, right. Michael?
Yes, I would like to support, if I can, the framing of a resolution, knowing that the resolution would be adopted by our full board after the City Council acts on the Soho NoHo neighborhood plan, but of course, before the council would act on the intro we've heard about tonight. I think that what we could do there, and again, Claude is right, it's been in all of our resolutions that there is no pathway and we're very disturbed, but I think now we're clearer in our mind that it's not going to be in the legislation that the council is going to adopt in 2 weeks. They do not have a pathway planned and they're not going to add it to it now. But if we did a resolution that went to the City Council, went to the City Planning Commission saying and the incoming mayor, we need a pathway to convert units into standard use group 2 residential units, and we need for the city to create some sort of a mechanism. Let's remember the loft board was created to deal with non-traditional residential units, and I think we're kind of asking for something like that here. We need for this city administration to create some sort of a mechanism whereby these units can be converted at a lower cost, more easily expedited, with all sorts of information from the city. We need something to guide this process to make it less onerous to those who seek a pathway to legal conversion to use group 2. I think we could do a resolution knowing it's not going to get to that city council before they vote on the Soho NOAA plan, but knowing that that's the next step that we're looking for as a community board.
Okay. I would like to hear from other people who haven't spoken. Donna, do you have something?
I just wanted to add something in here though, Frederica, since nobody has their hand up yet. Nobody has their hand up. I just wanted to add, I mean, you know, a 2-sentence, well, we're speaking and nobody has their hand up.
I just called on Donna Carter.
She didn't have her hand up.
But I'm running the meeting and I called on somebody.
Okay, but I'd like to speak to what Michael's saying, that, you know, that we're talking about passing a resolution so far after the fact when we need to take action tomorrow, right now. The resolution, if we want to go on record, we can do a 1-paragraph resolution that says we don't support this and we can pass that later. But Kana specifically and clearly said they're not withdrawing this legislation. You know, clearly, you know, to wait, and I agree, you know, with John Paul, we need to do this now and write a letter, and we need to do it, you know, in the next 2 days, because this is going to be a done deal. You know, and we have our positions already. It's reinforcing and clarifying and saying that this bill, what it's trying to, there's no pathway out of it. There's 3 pathways: discontinue the use, become a certified artist, or convert to use group 2. That's it. There's nothing on 2 of them. The artist certification, they don't even respond, and there's no pathway. And if we write a letter directed specifically to all the council members, they might ask some questions of each other and at least inform them. So I just, that's taking action. And it's in a simple resolution for Chris, if this doesn't get a second and it carries through and it can be withdrawn.
Right, I'm all in favor of action, and but what I feel after having watched what went on in the chat and heard how many people have questions, my feeling that just giving them a list of questions is really not adequate.
That's not what I put forward.
I know, I'm talking about what our original plan was. Donna, you have your hand up.
So I'm just going to agree basically with what Carter said. I think it's important before they do this vote for them to get a letter or something from us that says there is no pathway, we need these things. They need to discuss all these things, whether they will or not. Just it gives us an opportunity, might not do anything, to put something in front of them one more time. And then we can do something about this bill separately.
Thank you. Katie? We can't hear you, Katie. Don, is your hand up
Sorry,
again?
that was my fault. Are you?
Calling
Katie,
user 1 is Katie.
Yeah, I think you're, Katie, you can talk now. Sorry about that.
Yeah, okay, I figured it out. I totally support a letter and a resolution. I know it's like belt and suspenders, but I think I think we need something. Janine is saying something about maybe an exec meeting. I think we need something right away, and I think, you know, we could get the board to go on record again about this, because this is really so last minute, and you know, I think it's worth a double hammer. Really hammer it home.
Okay.
Can we do unanimous consent on that? Does
Janine,
anyone
your
think?
hand is up.
I just wanted to clarify, I mean, how we send, what we send, whether it's, let's say we send a letter. It can be a very strongly worded letter that's 1 page and short for decision makers to read. with
Yes.
attached 3 pages of questions organized by category, for the people who need to look at those questions to look at them, and for the people who just want to understand big picture to read the cover page. So in terms of form, style and format, and we have a position on JLQWA. It's in our resolution, and we have, probably 100 unanswered questions from tonight. And if we need, we can have an emergency exec meeting and get that out, but so it gets out to people before they make decisions. But this rezoning is being finalized by next Thursday, unless something changes. And that's why we
Right,
need
but-
to go
but-
fast.
Can I follow up on my comment?
Sure.
The reason I like the letter, because I think it can go faster. We have a position and we underline it. But I like the reso as well, because I think in the reso, we can talk about the broken and unsatisfactory, no, that's not even a strong enough, the broken and a disrespectful process that's gone on, and which is we've this month and the last week we've had new interactions which have disturbed us, have disturbed our community, and we have and I think there's a way that we should be commenting on that, the last minute itis situation that's been presented to us about this particular item. So that's part of my thinking.
Right, but correct me if I'm wrong, there's nothing that, in the ideal world, we would be able to write the resolution and or the letter and get it to people before there's a vote. But even if they vote, there's nothing to prevent them from establishing a faster, cheaper, easier pathway to legalization after the vote. It's ridiculous that it's not a part of it, but there's nothing to prevent it. Eugene?
But just to,
yes?
Can I respond to you?
Sure.
But just as we have this reso on the JLQWA issue in our pocket, if we had a reso about this process, this particular process, that could also be in our pocket if we needed it in the future. That's all. We're so fortunate that we have a reso and could do a strong letter on the basis of that reso.
Okay.
So why not get another reso that deals with the new issues that have come up as an insurance
Eugene?
policy?
Eugene? Your hand is up?
Yeah. I mean, I guess my preference is that the resolution timing, it just seems that it's just not going to, it's going to be too little, it's going to be too late. I mean, if that's something we do, I think we still need to do the letter to the electors, because that's something we can get out right away. And as to the responses from Councilmember Chin's office about amendments to the legislation, there's no promise that they will make amendments or what they would look like. I mean, I think that's very disingenuous, because they just proposed the legislation, several weeks ago, and they're already talking about amendments. But when would that happen?
I think they realized that they just completely screwed up by rushing this. But what I want to suggest is that we write a letter immediately regarding how this issue of the legislation has revealed yet again the deficiencies of the neighborhood plan with respect to a pathway to legalization. And it doesn't have to, as somebody said, it doesn't have to be a long letter, but it's easy enough to write. We should just go on the record in the quickest way possible regarding that, and then spend a little more time writing a resolution on the specific deficiencies and the questions we have about the legislation. Does that seem reasonable?
Well, I'm sorry, one thing in that
I had my hand
resolution.
up, but I just wanted to speak to that.
I'm sorry, I'll speak after Carter.
Carter.
Yes, first of all, we're just reiterating a position. The letter doesn't need to be approved by anything. This conversation in this committee empowers Janine to write this letter, because everybody here is saying, I don't want to use any bad language, but seriously, And we really need to hone in on this very specific issue because this is the community who lives here. And we need to use this as the specific narrowness to be right on top of that. And you know what? We can write a 2 or 1 page resolution on this and say that we're putting this forward before the board. We don't have the timeline to do it. It's there so that they know that's on its way to getting passed. If somebody, you know, if they're going to push this legislation forward, at least they know what's very narrow. Don't do it. We don't need reasons for this legislation that are very detailed. It's simply they haven't provided a way out. Why are they focusing their time on this? And the punitive aspect of it is, and the way that it's enforced is crazy to be talking about when nobody can get out of the problem. And to up the penalties is just disingenuous. We can work on that, but the aspect of the letter, they've given us a vehicle to narrow down specifically on this one critical point, is that there's no way out. The mayor's plan was delivered to us. The solutions that they're working on make a city council's plan, and there are no solutions that we can see, and they haven't talked to DOB, even talk about what Anita's, you know, been pointing out, and every other architect, professional architect. It's astounding. Should be in the questions, you know, the list. I think what Janine had put forward is absolutely right. The list of questions, just to see those questions, a reasonable person is going to really just call this process into question, that our elected officials need to represent us. I mean, you very rarely ever hear me say that, but in this particular case, they're not representing their constituents who actually live here. There's no voice. I mean, all the people who spoke tonight, you know, it's all the people that we all saw in every meeting. I mean, what we're on, this is like meeting 40, you know, or at least for me, maybe it's meeting 25 for all the residents, you know. It's a lot. And you know, all the people in the chat who spoke, we know them all, and nobody's listened to them. Yeah, it's astounding.
Janine, are you, well, we can talk about who's going to write the letter, but now I want to hear from people about whether we're doing 2 resos and just sending the reso off as proposed rather than as voted on. I really think people, I really think those folks look at things better when it's in reso form. And we can just say this will be presented to the full board at our December meeting, but we wanted you to know, you know, what was in the works. Does that seem okay? And then we'll do a more leisurely job of doing a reso on the actual legislation.
Can I ask a question? I'm getting a little bit confused. In the letter that we would send now and in the resolution that we would do at the end of the month, are we referencing both this legislation, the intro that we don't like, and the deficiencies of the Soho NoHo plan when it comes to a pathway for legalization? Are we referencing both in a letter and in a resolution? What is your feeling right now?
Well, I'm just going to jump in on the resolution. We have a resolution that outlined the deficiencies of the conversion. And, you know, we have on pages, I think 3 and 4 of the CB2 resolution outlines all the things that we're concerned about with. So we've already done that. So if we want to write another resolution, we could specifically address the legislation, and it'll go in inboxes for emails that are going to be disconnected on December 31st. But we've done that.
Anita?
Janine, can I jump in
Sure,
for a
Anita.
second? Yeah, thank you, Frederica. Yeah, I reviewed our resolution. I mean, there's 12 items about this. They're still current, there's still questions, they're the same questions in many regards. This is just, you know, really putting some salt into the whole thing and getting a lot of attention because it's so poorly thought out. We don't even know it's just a way of generating some revenue. It has very little to do with real people and real stress that's going on in our community. There's no way of anticipating what's ahead. They're giving us no out. So I have to say, I think our resolution has covered a lot of it, and a letter would directly respond to this. But I'm happy to go with the math, whoever, you know, either way is fine. But I really think a letter quickly, and maybe even link this meeting that we had, because we really received no answers to anything. And every time we ask questions, it's always, oh yeah, well, we're listening. We'll get back to you. That's been going on for a couple of years now, and it hasn't seemed to work. So that's my opinion.
Well, okay, so I agree with, I actually agree with you, Anita, because I don't see that we're going to change anybody's minds about anything with respect to the neighborhood plan. So, and I don't think there's anything new to say. I think personally, I just think we should focus on the legislation. There's this not even, I wouldn't even call it a presentation tonight. Katie?
So I just want to be clear. We have a resolution that covers many of these issues. Is that what we're, is that's the first thing? Okay.
Yes.
So based on that resolution, we can say, send a letter and say, we sent you this resolution in the past. We stand by this resolution. Please, you know, please pay attention.
Yeah,
Fine,
but we're going to be
you know,
sending it to the
now.
subcommittee. We're going to be sending it to the subcommittee, because they're going to be doing the vote. So we'll be sending it to city council, and it doesn't really matter whether their inboxes are disconnected on December 31st, because they will have done the damage by then anyway. Carter?
And,
You have your hand?
oh, no, wait, I'm not done. I have one.
Oh,
more.
I'm sorry.
So
Okay.
that's the first thing. That's the letter. But I was supporting a resolution reflecting what happened tonight. You know, that's different. That's not covered in the letter, and that's mostly about this process. That, you know, the inadequate and unsatisfactory process. And that's what I was thinking, that the new resolution should talk about the new experiences. I don't know what to say, you know, the new terrain. That's how I was separating it in my mind.
Mhm.
Oh, I put my hand down.
Carter?
Yeah, you know, as we're talking about this, you know, it just sort of reminded me that the public hearing already happened on this legislation. And, you know, it was introduced 2 days before the hearing. And that was the public comment period, and it's closed. And so the bill is, you know, at this point, it's where it is. The board's not going to be able to take a position. You know, Anthony, I think, laid it out. People are going to have left on vacation, you know, from things will have wrapped up by then. And providing a draft of a resolution and say that's being presented from the committee and just reinforcing the other issues, you know, they may not change their vote, but the introduction of this bill has given us another opportunity to comment on the very narrow issue of pathways. And we really should take that opportunity to submit that to the subcommittee and frankly, to the full land use committee, who's also going to have to vote on this, to realize that there are problems. And I think that what we're looking to do is you know, Commissioner Levin, in passing this, and charged city council with fixing what she saw that were problems, even though they all voted on this. But the problems are clearly not really being fixed. And if we don't ask the questions, the doors have closed on our public participation. The questions are what the public is asking right now. and the door is closing. They left this opening by putting forward this legislation. We wouldn't have been able to have this meeting tonight if they hadn't. And so we really should be speaking to this point, because it is the entree to all the other problems. But most importantly, these are my neighbors. This is me. This is members of our board. And to get lost in resolutions misses the point. They're failing us. And we haven't said that. We have a resolution, but we need to say that. And this is it. This is the majority of owned units in Soho and NoHo. The majority, more than that. I mean, it's astounding to be told. People who make our community, you heard tonight, I mean, the majority, this is one of the most stable communities that I know of as far as people not leaving. So, and it's because the mayor has his focus, which we're not talking about, but this is different. And Frederica, I invite you to talk to the people who live here. You know, when we talk about putting it in reso form, there's no bigger emergency than right now.
Carter, where do you think that I don't agree with what I'm hearing?
No,
I think we're
meaning
here. I
waiting
think
for
I'm
the
hearing
board.
two things. I think I'm
Waiting
hearing
for the
two
board.
things.
I'm not, let me just, Janine, let me just address what Carter said. I opened the conversation and I suggested either two resos, a letter and a reso. I'm open to anything. I wanted to hear from everybody, and there's still a few people that haven't spoken. You know, and I don't know how we can decide unless but I also know we can keep going around and around on this. So Janine, if you want to move it forward.
I think maybe we should break this down. I think we should write a letter. And I know there was press on this. Somebody just said a comment about a press release. I know there was some press on this call. I don't know if they're still here. I think Dashiell has come off. The Village Sun was on earlier. But we should write a letter, and it should be short and sweet, and it should have a long list of questions, and it should be about the lack of pathways and the fact and the legislation and so forth. If we want to write a resolution that's going to be after the fact on this on the legislation, I'm fine with that. I think that's kind of belt and suspenders because that may be a moot point by the time it gets passed. So I think we should focus our energy over the weekend on getting a letter out by Monday.
Now you're talking, hold on, all right. I'm sorry, now I'm not.
I haven't written a letter yet, so I don't really have what's.
No, but okay. Let me take it back a step. Are we going to make any further comments on the Soho NoHo the Soho NoHo neighborhood plan and its deficiencies?
No, we covered it. We have covered that.
Okay, I want to hear that from everybody. Raise your hand if you think there's still something for us to say about the neighborhood plan. Okay, Carter, John Paul, Anita, can't see you guys, but are you in favor of opining further on the neighborhood plan?
I'm not.
You're not hearing what I said before, and we're not opining on the plan. We're pointing out that this bill.
That at one point at Carter, and I
No, but it's being consistent with our past resolution to point out that this legislation misses the point that there are no pathways that are clear.
No, then you're writing about the legislation, not about the neighborhood plan. Right? I mean,
I don't think we should.
Yes.
Go ahead.
No, you.
Okay, hold on. Let me make my sound better. I don't think we need to do any more on the resolution. We knocked them pretty heavy duty there. It was very concise, and don't mess with it. This is a new issue, a new item. It ties back to it, and it only enforces what we said in the resolution. I mean, I just reread it today. That's why I'm fresh on it. And, you know, this is just the modus operandi. There's nothing really unique about this.
All right, so that's the item. The neighborhood plan is the thing that's gonna be voted on in the next week or two. We have more time with this, with the legislation. We might not have that much more time, but we don't need to put something out in the next 2 days or over the weekend about the legislation. So is there sentiment for dealing with the neighborhood plan any further? Do we want to, yes, Michael?
Let me just recommend, this may be one way to bring the two together. If I'm not there, I'm not there. In a letter that could be done this weekend and sent out, it could say the introduction of this ill-advised legislation points to one of the deficiencies that we have already stated in our resolution, that there is no pathway for legalization. We could kind of do both in one letter, which means that we don't need to wait for a resolution. We're saying that this is ill-advised legislation. We know the timetable isn't there, but we're saying it points to a major weakness that we pointed out in our resolution, that there is no pathway for legalization. We could do both in one letter.
Right. I know.
I think that makes sense.
I mentioned that at one point, but I feel as if we should focus on our energies in the last days of December on the thing that's really gonna make a difference.
And I
So my
think we
personal
can.
opinion is that that's the legislation, not the neighborhood plan.
No, I think it's all of the above, because if anything happens, it's gonna be happening in the next week. That's why we need to write a letter now.
We're trying to prevent a second on the legislation, Frederica.
Say it again, Carter.
We're trying to prevent, right now, for legislation to be introduced. It's been introduced, but I'm not sure how many, but it needs at least a second council member supporting it to even go forward. And right now, only Chin's name is on it.
Right, so I'm saying that that's not gonna happen in the next week. That's what that Kana person said. He said
But
they're
I
open,
think it's
everything's
urgent.
okay.
It is urgent, though.
It is urgent
to get it
because
out
it's either
there.
gonna
Let's do it in
happen. Yeah.
January, everybody.
Pardon me?
So
I
what?
said, I'm
We
not
wanna
saying we should
get-
do it in January.
No, you know what, if we want to, I mean, I think that Michael's suggestion is a perfect way to tie it together. It's ill-advised legislation points to a deficiency in the pathway for legalization and then
that's
link
what
our
I said.
resolution and list our questions. And if somebody wants to do a second resolution, somebody else can take the lead. I think that.
No, but there's the. All right, so does everyone feel that just a letter regarding Bill 2443 is all we have to do? It may say, that letter may start with, this issue points out all the deficiencies in the neighborhood plan, right? And et cetera, et cetera. We can mention the
But we
neighborhood, plan,
can't-
but we should make it about the bill.
Th-
Eugene?
This is a technical issue, Frederica, in that we can't take a position on the bill until the full board votes. What we're saying is that this is where the committee was, it highlights the deficiencies, as Michael suggests, but this is still going forward to the board. You can't take a position on the bill yet because the board only has the board's position. It never is going to get there.
Whatever we send can
So-
be in advance of voting on it, okay? We don't have to wait.
That's not true. That's not true. We cannot send a position of the board in advance of the board taking position.
We can say, this is what somebody other than I just said earlier, we can say, this is what is going to be put in front of the board at our full board meeting.
That is correct, but you can't say that it's the board's position. You have to,
Okay,
you
I
have an
misspoke.
existing
This is what
position.
we're going, okay. Eugene, did you want to say something?
I actually, I'll hold off.
Okay, Donna?
Yeah, I'm sorry. I lost right when Michael was talking. I lost my internet. So he is suggesting, and I just wanted to get clarification on exactly. He is suggesting a letter go now soon before the vote to reiterate our position. Just so I'm clear on what exactly.
Let me restate that simply, that the letter would state that we've seen this introduction, we have problems with it, these are the issues that it raises, and it also points to the inadequacies of the Soho NoHo plan, one of them being no pathway for legalization. So that we do both in one letter, without needing a resolution, because it's not a new position by the board. It says we have issues with this current intro. We need answers to our questions, and it points to the deficiencies regarding a pathway to legalization in the Soho NoHo plan.
Right, and therefore give us the opportunity to sort of highlight what's lacking in the Soho NoHo plan.
That was my proposal. Thank you.
Great, sounds
Yes,
good.
and I believe that I suggested that, but it does not address the new position that we have to take on Bill 2443, if we want to stake new ground about that.
We can then have a separate resolution opposed to that legislation.
Yes, that's what I'm suggesting. Eugene?
Yeah, I mean, I mean, I would agree with the letter. I mean, if we can't take a position before a full board vote, I mean, can we at least give a summation of all the questions that were raised by the community that were just simply not answered or deferred, or, you know, they didn't send the right person. And, you know, we weren't able to have a proper discussion about the bill. And they've also linked the bill to the Soho NoHo rezoning. I mean, it's part of the description of the bill. So I think that gives us an in to also, you know, reiterate our position on the whole Soho NoHo rezoning, which is, it's ridiculous. And on top of that, you know, there's been absolutely no way to do a pathway for this conversion they keep talking about.
Susan Wittenberg. Unmute yourself.
Yeah, I just did, sorry.
Sure.
You know, going back to Carter's sense of urgency here, and I don't remember ever seeing anything like this, where something came up, you know, practically overnight, where, you know, our city council representative or someone comes in and with a proposal for change that can't be impacted because there's no time, and this gigantic thing is happening. I mean, it's so, I think that's part of why we're struggling right now, is that we haven't had something like this happen. And, you know, I'm cynical enough to think we're gonna have no impact. And I think that we have to make the strongest statement we possibly can right now, because there's nothing else we can do. I mean, this is the fastest moving train we've seen. And our normal way of responding to things, we don't even have the time to do it. So, you know, I don't know what our options are.
All right, so I think we talked this over enough. And what I want to suggest, and I think that things are going to change every day about the legislation. So why don't we just get a letter out with what we have, reference both the neighborhood plan and the legislation, and in a couple, and get it out right away. And in a couple of days, we'll see where things stand with the legislation, and we'll see if we need to do anything else. All right. I see a thumb. Could I see any more thumbs?
So, how would we, in a couple of days, what would happen? Would we hold another?
We're going to pull together the chat and extract the questions. But, well, this is personally, I think one person, some group of people should pull the questions out of the chat. Meanwhile, somebody else write a letter. And we've got something that's going to make sense to people from the chat, by the time the letter's ready, we put them together. And if they're not together by Monday morning, we send what we have and hold the chat questions.
So are we going to, if something new develops, how will we respond to it quickly?
Okay, well, all right, so let's take a vote. Is anyone in favor of legislation 2443? And then we'll have a position. Does that sound okay, Katie?
Okay, that's good.
All in favor of 2443? Eugene, you're John Paul, Anita? Well, when they would, anybody there?
I'm sorry,
All
what are
right,
we
all
voting?
in favor
What are we voting
of
on?
denying, all in favor of objecting to this bill?
Oh, okay.
Oh,
Right, sir.
objective, yes.
Okay, so that's unanimous. All right, a letter it is, and we'll see what happens on Monday, but we have a position now. Janine, your hand is up?
No, that was just a,
Oh, that was your hand being up, okay. All right, Eugene, did you want to speak, or you were just in favor of the objection?
Yes, that was just in favor of the objection.
All right, well, thanks to everybody who came. Thanks for this spirited conversation. I wish they would bring us better stuff.
You're here.
Thank you very much, and
good night.
good night,
Night.
everyone.